The CD States Exhibit 374. Actually, the 374 is the full extraction, and 375 is the tag one. But
it looks like both are there, open at the bottom. This is the tagged only report.
okay, so can we, looking at the tagged report, States Exhibit, 375 for the record is the tagged CD. Can you tell us which part of the analyzed data that we hadn't gone through?
We still haven't talked about the call logs.
Okay, so going to the call logs.
Which mouse? Okay. Okay, so I tagged every call on the 20th and the 21st
Of 2016.
Of 2016, yes, ma'am.
And so every call into phone number, and again for the record, we're referring to phone number 210-980-5417.
Yes.
The phone belonging to Otis McKane.
Yes, ma'am.
So can we, without having to go through every single one of these messages, if we can start at the 20th, please, and just show the court the calls in and out.
Oops. Okay, starting at the 20th, it starts here at 12:17 a.m. Then these are outgoing because the arrow was pointing out, and these are incoming. And these are the times in which these calls occurred.
And from the testimony that we left off on Wednesday, I know you testified before that as well in this hearing, but on, let's see, the call 346-900-3385, is that the phone belonging to Christian Fields?
Yes, ma'am.
Now, there's some calls from an individual named George, is that right?
Yes, ma'am.
That came in on the 20th, one at 4:03 p.m. and one at 5:29 p.m.?
Yes, ma'am.
If we can scroll down. There's a call from on 11/20/16 at 8 p.m. from someone named Simone, Simmone.
Yes, ma'am.
And then, can we scroll down to the end? And so do you, just kind of so the court can see the various calls, the last call that came into the defendant's phone was on November 21st, 2016 at 2:55 p.m.?
Yes, ma'am.
Okay, and then the first call in the series of calls that you tagged, the incoming and outcoming calls, for the record, I think you tagged one from 11/19/2016 at the very top? Is that right?
Yeah, so the most recent one I tagged was from 10/21 of 2016.
All right. And do you know who that number belongs to? The 210-574-9545?
Yes, that's, just double check the tag name to make sure. It's Sandra McKane.
Okay. And so the calls from that number, 210-574-9545, according to the ones that you tagged, range from 10/21/16 through...
That was the very last call, too, at 11/21/2016 at 2:55 p.m.
Okay. And all of this information that's on both the full extraction report, States Exhibit 374, and States Exhibit 375, which are the tags that came from the full extraction, States Exhibit 374. Is that correct?
Yes, ma'am.
Okay. All of that information was on the defendant's phone, 210-980-5417.
Yes, ma'am.
Okay. And the information Was it manipulated? Was it changed? Was it edited? Was it altered in any way during any of the extractions?
No, ma'am.
I'll pass the witness.
On the phone calls, Detective Knox, the ones that are on this extracted part, right, that we're talking about, the ones you're showing right now,
Yes, sir.
were all those calls, let's say on 11/21, those were all the incoming and outgoing calls. I mean, on that one, you didn't discretionarily pick and choose, right?
No, I believe I tagged everything on 11/20 and 11/21.
Okay. And then you stated that there were some calls back in 10/21. Did I hear right? Yeah.
10/21 was the earliest, and yes.
Okay. And how did you decide to tag, let's say, that call on 10/21?
I was advised that that number was important because it was his mom.
Okay. And so let's say, did you go to 10/20 of 2016 and look and see what calls were there? Or, I mean, how did you decide just to go back up to 10/21 and not 10/15, let's say?
Those, because I did a search for that phone number, and it just tagged every time that phone number was stored on the phone as a call.
And so the earliest, because I can't tell from here, so there's some calls on 10/21, 10/30, 11/5, 11/8, 11/9. So then what you were doing, you were searching for specific phone numbers. Is that how it went?
Yes, sir. That specific phone number.
And what specific phone numbers were you told to look for? We know Sandra McCain's. What other numbers?
Just that one.
Okay. And so we saw where it said Simone and Sandra, etc. So how did you, is that because on the phone it's the contact is George or Simone or what?
Correct. Yes. So Celebrite is pulling that contact name from his contact list. If it is not stored in his contact, you won't see anything. You'll just see the number.
So like that one, if you click it, it won't have a name because on the contacts it did not.
Correct.
Have a name or it was not.
It was not in his contact list.
Okay. Nothing further on that issue.
Okay, and just. Your Honor, may I approach?
Yes.
All right, Detective Knox, I'm going to show you what's been marked for purposes of this hearing as State's Exhibit 377. It's multiple clipped and stapled documents from various numbers to the defendant's phone. The phone. One second. Okay. And have you had an opportunity to see these when you did the full extraction?
Yes, ma'am.
Okay. And State's Exhibit 377, these text messages pertain to what in particular?
Communications back and forth, asking for drugs, narcotics, things like that.
Okay. All right. So, Judge, for purposes of this hearing, the State moves to introduce State's Exhibit 377 for your consideration for this hearing. And the contents, the printed out contents on State's Exhibit 377 are included in the full extraction report, State's Exhibit 374, the CD.
Yes, ma'am.
Matt, are you passing it?
Yes, I'll pass it.
Oh, just for Rodar, on this issue of the text messages, this is off the full extraction. These are not all the records of the full extraction on text.
I'm sorry.
Okay. These records that we have here that are printed, Are they all the text messages from the full extraction?
No, sir. Just the ones dealing with the narcotics.
Narcotics, okay. And did you place a date on it? You know, how far back did you go?
Just everything in the phone that related to it.
And how far back did it go, if you know?
I don't know. I couldn't tell you an exact date.
Okay. And then how did you pick and choose, you know, let's say I said, bring me 2 tires, let's just say, and we know that in narcotics there's code words, right? And how did you pick and choose which ones you thought were narcotics related text messages?
I didn't. I just looked and saw all the text on the phone. I didn't print those out.
Okay. Oh, you
We
printed.
printed
Okay.
to introduce into
Is the
court.
mic on? Can you touch
Yeah, I
so
don't
for
think
the
it's on.
record, so it's clear, he did the extraction report. We printed these from his full extraction report from the defendant's phone in order to introduce to the, present it to the jury. But it's from his report from the defendant's phone.
Okay.
For purposes of the hearing, we have no objections.
Okay, so it's admitted for purposes of this hearing.
We'll pass it over to Mr. Arnold.
No question. Thank you, sir.
Any argument about anything?
Judge, we have, not for Mr. Knox. We have one more thing we want to present to the court
Okay,
for purposes of this hearing.
okay,
So may Detective Knox step down?
yes.
So, Your Honor, this time, for purposes of this hearing, the state's playing State's Exhibit 378, which is a jail call.
Mm-hmm.
And so with the, it's a video.
Yeah. Let's go to 613. I believe it should be a video visit between the defendant and his mother, wherein he's saying that the police gathered from him his keys, his wallet, and his phone. That's 613.
feed in that.
Yeah.
Okay, you know, it's like you gotta say,
That's something to do on TV. I was wondering.
yeah, that's TV. No, it's nothing. It's nothing. It's
They're
nothing.
showing like all my high school sports stuff.
Yeah,
High
it's
school-
not. Don't stay careful. In God, is stay careful. God is our protection. Just stay careful. Don't give up. Just stay careful.
They say they got a lot of stuff on me on the nose and stuff.
That's negative. Don't feed in that.
Yeah.
Okay, you know, it's like you gotta say,
That's something to do on TV. I was wondering.
yeah, that's TV. No, it's nothing. It's nothing. It's
They're showing like
nothing.
all my high school sports stuff.
Yeah, that's your high school
They
stuff.
said it
Yeah.
was trying to look bad, or they was just
That's just, you know, just checking up on your background, you know,
yeah,
the type of person you are, and, you know, stuff like that,
yeah.
you know, yeah. It's, you know, it's okay. It's
I thought
okay.
it was okay. I've been there.
God is good. Okay, God is good.
No doubt
That's-
in my mind. And it's the
Okay.
only thing that I'm worried
Okay.
about is
God has got this. God
y'all.
always knows. We good. We good. We got God. We got God. We got faith.
Hey, you been to my house? Can you? Oh yeah, I was gonna tell you. You need to get my house keys from the
Well,
in front of book.
from the office.
Yeah, go to the when you done. Go to the where you reported it. Ask them, can I retrieve some property from Otis McKane's property box? I got a wallet,
You know,
my phone, and my keys. I mean, yeah, my house keys. So I need to get my
Is it
house
here?
keys. Yeah.
Okay, I
I need
asked
to
you
get my
about
house
it.
keys, and let Christian have that TV, and let Jamari have a PS4. And
Judge, so for purposes of that, we put on the information, the search warrants, the information from the extraction of the defendant's phone that we would like to introduce, and then the last one was a video visit with the defendant saying they took, his keys, his wallet, and his phone. And then we're able to link the phone up to this defendant from the various images on the phone, including his driver's license, including selfies that he took of himself, and all calls. And the last call to or from the phone that the court heard was November 21st, 2016 at 2:55 p.m. And then the court knows that the defendant was arrested somewhere close to 4 p.m. on that same day. Okay. Also, the emails that list Otis McKane, and then the number goes back to the defendant as well. So we've linked it to him, plus the information we want to elicit through a search warrant.
Okay.
So if I might just inquire something, so the phone call, making the phone, this jail call,
It's just one of the things.
yeah, but I mean, are you offering that jail call, or just for the court's information?
Under Rule 104 for the court to consider.
Well, only the court, right, not for the jury, right?
No.
No, but we're probably going to offer maybe that same disc, portions of it for the jury, but for right now, we're just offering
Okay.
for the court.
Judge, the objection would be on some of this partial extraction, if you will, that they're not relevant, Your Honor, and if they are relevant, this probative value is outweighed by its unfair prejudice. In regards to the number of selfies, if you will, that they're offering, clearly one of those would authenticate that part of the issue, they're trying to authenticate that it's Otis McKane's phone. One photo, one selfie will do it, as opposed to all the number that is on the partial extract. And with regards to the Glock, there's multiple photos and searches of how to disassemble a Glock, photos of a Glock, etc. And we are just asking the court, again, under the probative value as outweighed by some unfair prejudice or confusion of the issues, to only allow, whatever number the court feels is relevant. We'd say 1 is relevant, and that would be it. In addition, Your Honor, Google searches with regards to an officer that was killed at any time in California. I don't remember right now because of Wednesday, but just generally that those Google searches are not relevant at all for purposes of the 2 special issues. And so we'd object to that, any searches unrelated to this case. Now, I would submit that the searches that are relevant are searches with regards to the killing of Officer Marconi, but any searches regarding any other things are just not relevant.
It's the state's response, Your Honor, that the Glock searches, and we went through each one for you, and they are, each of them appears to be a different search for the different image, a different search on how to disassemble a Glock or an individual holding a Glock, or an individual shooting a Glock. And the state believes that this goes to the defendant's intent, motive, and planning. These are all on his phone shortly before he killed Detective Marconi. Also, the Google search pertaining to a police officer in California, that Google search was on November 12th of 2016, approximately 1 week before the defendant killed Detective Marconi. The Google search is a police officer, a deputy in California, who was shot twice in the head, very similar to what we have in our case right here. And the relevance of that, the state believes it's highly relevant, and it goes to the defendant's planning of this offense, and it goes to future danger. Additionally, the selfies, goes to the identification of the defendant. And so the pictures of himself that he took, you can clearly see his face, the Texas driver's license, the insurance registration, again, are all under the identification tab. So they're highly relevant, and they go to the defendant's intent. The others go, the Glock and the officer go to the defendant's intent, motive, planning, and obviously future danger.
If I may briefly respond, Your Honor. The purpose of the selfies, I would imagine, is the authentication issue. And I would only submit to the court, and maybe I just saw it differently from my angle or something, but some of the photos are different contrast, and we believe that it's like inflammatory, Your Honor. The idea, if they've got his ID, they've got his insurance card, they have one selfie, that is sufficient to establish authentication. All these other selfies are not relevant, and the court we can try and pick one of the selfies, and that would establish the relevance of that issue. With regards also, I didn't bring up, Your Honor, there were some searches with regards to Round Rock, and unless and until the state can tie the Round Rock event, which was a gun show or something like that, to a particular firearm, we would suggest to the court that that's not relevant also. If it is relevant, its probative value is outweighed by its unfair prejudice and confusion of the issues, Your Honor. With regards again to the search of the particular shooting of an officer in California, again, Your Honor, our objection is that for purposes of this trial on Officer Marconi, that's not relevant.
Just in response to the Glock images and the Glock searches on the defendant's phone, the state also would like to introduce those into evidence to show that it impeaches the defendant's statements that he made to Detective Duke when he told Detective Duke that he doesn't know much about guns. And we clearly have him doing these multiple searches on guns, and then obviously watching videos on how to take apart a Glock. So, he said he didn't know what kind of gun it was.
And just briefly on that one point, if anything, it reaffirms what he said. I don't know too much about guns, because if you know about guns, I've generally known how to disassemble a Glock for a long time. I wouldn't need to Google it. If anything, it doesn't impeach him. It confirms what he said. I don't know too much about this guns, because this Glock searches were being done in September. If I remember correctly, it started September the 16th, if I remember correctly. So as far as trying to impeach him that he doesn't know too much about guns, if anything, it confirms it.
Well, then he can withdraw his objection to all those images, and you can argue that.
I have a lot of, that's not my only objection. I'm just responding to the idea that it impeaches him.
Right, so the arguments, the arguments that I have before me now, I'll overrule the defense 404 objections. I'll also conduct a 403 balance, and I'll overrule those objections as well. Anything else?
No, Your Honor.
No, Your Honor.
You want to bring in, y'all ready for the jury?
Yes, sir.
And Judge, did we resolve what's going to happen with the alternate before they bring it in?
We're going to put the alternate where? We're going to put the alternate in the corner.
Okay.
No,
All right for the jury. You may be seated.
All right, members of the jury, welcome back. Hope you had a good few days. Hope you were relaxed, as you deserve to be. This has been a long trial. You definitely all understand that. The rules in the courthouse have changed just a little bit as a result of COVID. So the folks in the gallery, everybody that comes in, also the jury, y'all should wear your face coverings at all time. If there's an issue, just let me know, and we can deal with that. Everything is on a case-by-case circumstance, so we'll always figure things out as we go along. The attorneys and the witnesses don't have to wear them because they have to speak. We want to make sure that you can see them, that you can evaluate them, that you can use all the senses that you use throughout the course of your life to make sure you know what the truth is. Remember, it's up to you to determine how credible each witness is. It's up to you to determine how much weight you put whatever piece of testimony they provide. You'll see me take the mask on or off depending on whether I need to speak or not. So if I need to speak, I'll take it off, and if I'm not speaking, I'll put it on. If there's any questions with that, just let the bailiff know, and he'll advise me, okay? So before we get started for today, do any of you have any questions for me? All right, there being none, remember the rules I gave you throughout the course of the trial, and if any of you need a break for any reason whatsoever, please let me know. I want to make sure you're comfortable. All right, State, you can call your first witness.
Thank you, Your Honor. At this time, the state calls Detective Justin Knox.
Swear you in, Detective. And I know you've been sworn, but do you solemnly swear or affirm that the testimony you give in this trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. You can just introduce yourself to the jury, make sure everybody can hear you in the microphone.
My name is Detective Justin Knox.
State.
Thank you, Your Honor. Detective Knox, how are you employed?
I'm a detective at the San Antonio Police Department.
And how long have you been a police officer with the San Antonio Police Department?
15 years.
Okay. And can you briefly tell the jury about the various positions you've held over the 15 years with the San Antonio Police Department?
So for the first 8 years, I was on patrol in various spots throughout the city. Then I promoted to detective, and I became a uniform evidence detective for 3 years. That's where I was still on patrol, but I collected evidence, things like that. And then the last 4 years, I've been in the technical investigations detail.
And what are your job or your responsibilities and duties in the technical investigation detail?
Okay, so any crime involving computers, phones, digital evidence in any shape or form, the detectives investigating those cases will bring them to me, and I'll go through them and try to help them out as far as anything they need on their case. So we're mainly a support unit for the investigators.
And do you work with other investigators or detectives in that unit?
Yes, ma'am.
Do you work with a detective by the name of Brian Stoll?
Yes, ma'am.
And on this case, specifically under SAPD assignment number 16253595, did you work with Detective Stoll pertaining to a cell phone belonging to Otis McKane?
Yes, ma'am.
And that cell phone, in your unit, do you all classify or label cell phones a particular number, beginning with the CF?
Yes, so any item that comes into our unit, it's assigned by the case number in the original investigation, but we also have a unique number that we use within our unit to categorize things and find in our database.
And so the cell phone pertaining to Otis McKane, what is the number that was assigned in your unit to that particular phone?
I believe it was CF6134.
And is there do you have information in front of you, the serial number of that particular phone under CF6134?
I do not.
And CF, what does that stand for?
Just computer forensics, because that's the unit we were in, so that's how they started the number.
And how, when you or Detective Stoll or another detective in your unit, when you all receive the evidence, whether it be a cell phone, computer, whatever it is, in this case a cell phone, what do you go about doing first in order to view the contents?
The investigator will bring us any pertinent information. We have an intake sheet, so they bring us the intake sheet of what they request on the phone, the warrant, our consent, any of that stuff. It all comes together. Then typically we'll hook a phone up to a device that extracts all the data. Once that data is extracted, we put that extracted data into another program that will parse all the databases and everything inside of that phone and show us all the images, all the text messages, anything that was on the phone.
Your Honor, may I approach?
Yes.
Okay. Detective Knox, I'm showing you what's been marked as State's Exhibit number 376,
Okay.
State's Exhibit 382, State's Exhibit 379, and State's Exhibit 380. Do you recognize these documents?
Yes, ma'am.
Okay. And State's Exhibit 376, this is from Detective Stoll, is that correct?
Yes, ma'am.
Okay. So in this case, pertaining to cell phone number, an LG gray and black under CF 6134, serial number 512CYF T348819. That particular serial number. Did you work with Detective Stoll on that particular phone?
He did the extraction and then I did the report. So, yes, ma'am.
And the extraction that Detective Stoll did was pursuant to a search warrant, State's Exhibit 373.
Yes, ma'am.
For the LG cell phone, gray and black in color, found with
Yes.
the defendant Otis McKane. Is that correct?
Yes, ma'am.
So State's Exhibit 376, can you tell the jury the jury heard from Detective Stoll in the guilt-innocence phase about the extraction process, but can you tell the jury just briefly how Detective Stoll goes about extracting this particular file?
Okay. So, I will also do extractions, I just didn't do it in this particular case, so I'm familiar with the process that he does. So in this process, he hooked the phone up to a device called a Touch 2. He hooks it up to the left side, and then on the right side he has a hard drive or a flash drive of some sort. He picks the profile of the phone out inside a Touch 2. It's a touchscreen, just goes and finds the profile. And then in this case it was a physical, meaning it grabbed every part of the phone from the first byte to the last byte, just every part of memory. And that extraction came into a single file onto his flash drive, at which point he gave it to me to do the report.
And is it common that multiple detectives, or two detectives in this case, one does the extraction and another will take the information from the extraction and then put it into a readable report, what's called in this case cell-write, is that right?
Yes, ma'am.
Okay, and why does that sometimes happen?
Sometimes the detective will do everything from start and finish. There are certain cases where, like in this instance, the detective was not going to be available, so I did the report. In my office, sometimes I will have detectives actually send me phones from other parts of the state and other states. They actually send them to me. I will process that phone because I have technology that they don't. So I'll process that phone and then I will mail the phone and that extraction back to them, and they're responsible for doing the report. So it is common for one person to do the extraction and another person to do the report.
And what training and classes have you attended in order to know how to use this technology?
So the Secret Service has a facility in Alabama called the National Computer Forensics Institute. And so I've been there multiple times. I've been there for getting extractions and data off PCs. I've been there for advanced forensics training. I've been there for a class called Mobile Device Examiner, which relates to cell phones. And that particular class is 4 weeks long. So I was there for 4 weeks. I got a certification, Celebrite Certified Operator, and that allows me to pull data from the phone, make reports, and then present it.
Are are you or Detective Stoll or any other detective at the San Antonio Police Department, are you all able to edit or change any of the information when an extraction is done from a particular cell phone?
No, ma'am. The single file that comes from that device, it's uneditable and it's unreadable. If you were to open it up, it would just look like gibberish. There's a bunch of funny characters, everything else. There's just no way to edit it.
Okay, so it's, and the purpose of that is the integrity of the extraction. Is that correct?
Yes, ma'am.
It doesn't allow for anyone, a detective or anyone else who's performing the extraction, to go in there and change any of the information or add to it. Is that correct?
Correct. And then even further than that, once the report is made, the report is not editable either. You cannot change the report. You can't add things to the report or delete things. What comes from the machine is what you will see in the report.
And in this case, Detective Stoll, who performed the extraction that the jury heard about already when he testified a couple weeks ago, you then take that information and how do you go about creating a report from the extracted data?
So the first thing I do when I get an extraction or a file from Detective Stoll or any other detective that I'm tasked with making a report is I will run what they call a hash against it. So in this file, or this paperwork that Detective Stoll that came out from the machine, it took that single file and created a hash of it. So it's basically a signature. It's a long string of numbers and letters to show that this file matches with this signature. So when I get the file, I will take that same file and I'll run it through my hash program, and it gives me a series of letters and numbers. Then I look at his extraction, I look at mine, and if they are exactly the same, that means that file has not been changed and it is exactly the way that it came from that machine. If any of that in that string of numbers is different, then I would not use that file. So that's the first thing I do. So I verified that the hashes were matched. Then I took that single file and I put it into a program, a Celebrite program, and I processed it. It parsed all the data out and it showed me all the text messages, call logs, everything that was on that phone.
So looking in front of you, the document that Detective Stoll testified to for the extraction, which contains his hash number, or the hash number from his extraction of CF6134. Do you see that?
Yes, ma'am.
And is that State's Exhibit 376?
6.
Okay. And so that particular one, can you look at that, and do you have your document in front of you where you printed out the hash that was created when you performed your report?
Yes, ma'am. So that's State's Exhibit 382, and that's a screenshot from my computer, and it shows Detective Stoll's original document, which is State's Exhibit 376, and then behind that is my hasher program where I ran that file, and it showed its hash result, which shows that they match.
Okay, and so it's the exact same hash number from Detective Stoll's extraction of CF 6134, and that hash matches the hash that you have from your Cellbrite report.
Correct.
And are you also able to confirm whether or not on Detective Stoll's report pertaining to, again, all of your testimony today is pertaining to the LG gray and black cell phone CF6134. Is that correct?
Yes, ma'am.
So I don't have to keep saying that number, just so we're...
Yes, ma'am. Yes.
Okay. So looking at Detective Stoll's printout from the extraction, State's Exhibit 376, the serial number that's at the top right corner of that page, 512CYFT348819. Are you able to confirm that the extraction he did on that serial number matches the Cellbrite report that you used and confirmed looking at the particular phone belonging to the defendant?
Yes, ma'am. There's a photo of that phone with that serial number.
Okay, and do you have that in front of you?
Yes, ma'am.
Okay, and what is the exhibit number of that?
State's Exhibit 380.
And the photo of the phone on State's Exhibit 380, does that serial number, the one that I just read in the evidence, match Detective Stoll's extraction? State's Exhibit 376, his report.
Yes, ma'am.
And is there a telephone number associated with this extraction under CF634?
Yes, ma'am.
Okay, and what is that what is that cell number, please?
So in State's Exhibit 379, which is a picture of my report, the cell phone number listed is 210-980-5417.
And how are you able to get that number when you do, when you take the extraction and then create the cell right report?
So that number is assigned to the phone to various other numbers, and when it does the extraction, it finds that number and puts it into the report.
Okay. So it finds that number, and then you've confirmed that the serial number matches.
Yes, ma'am.
Okay. You're on a minute first?
Yes.
So looking at State's Exhibit 380, it's a 2-page report. What is that specifically, State's Exhibit 380?
It's pictures of the phone, the front of the phone, and the back of the phone that has the serial number attached to it.
Okay. And when you say the phone, whose phone are you talking about?
Otis McKane's phone.
Okay. And do you see Otis McKane in the courtroom today?
Yes, ma'am.
Okay. Would you please point to him and describe what he's wearing?
Gentleman over there wearing the blue shirt and blue pants.
And where is he seated?
Fourth to the left of me at the defendant's table.
So for the record, you've identified the defendant, Otis Tyrone McKane?
Yes.
All right. So the original State's Exhibit 379 has Detective Stoll's name as the examiner, the extractor. Is that correct? On 379. Yes. Okay. So, Your Honor, this time the State moves to introduce State's Exhibits 380, 382, and 376.
May I take a briefing on word item? Judge,
Yes.
Detective Knox, with regards to the photo of the phone, where is the phone?
Where's the phone?
Yeah.
Property room, probably. I'm not sure.
Okay.
Or maybe it's here.
Okay. Did you ever physically have the phone
No, sir.
yourself? So, as far as the chain, if you will, you know what chain of custody is.
Yes, sir.
To your knowledge, the phone at some point was in Detective Stoll's possession?
Yes, sir.
But when you got it, this whole sequence of events that the prosecutor's been talking about, you did not get the physical phone?
Correct.
Okay. All you got was the USB extract, the extractor, correct?
Yes, sir.
Okay. Just on the chain of custody, Your Honor, we would object, it goes to the weight, not the admissibility.
I'm sorry, sir. It goes to wait.
Just, we are objecting to the chain of custody.
Your response?
Well, I can respond by asking more questions, but it's our response is that Detective Knox testified that that's common in the law enforcement field with this type of technical investigations, that one investigator does the extraction and uses the phone for that, and then he takes the information from the extraction and puts it into the cell right report to have a readable report.
Okay. Overall?
So, Detective Knox, the phones that y'all received, if it's in this case, the San Antonio Police Department homicide case, after Detective Stoll does the extraction, where does the phone usually go?
It usually gets returned to the detective with the report.
Okay. And then from there to the San Antonio Police Department property room?
Yes, ma'am.
Okay. And again, when you told the jury about how, you said with the Secret Service, you'll often receive phones from, you said other detectives or investigators from within and also from around the United States.
Yes, ma'am.
Okay, to perform the extraction?
Just the extraction, yes, ma'am.
And so obviously you need the phone for the extraction, is that right?
Yes, ma'am.
So Detective Stoll would have to have the phone for the extraction?
Yes, ma'am.
And the pictures that State's Exhibit 380, the picture of the front and then the inside of the phone with the serial number, those would have been taken by whom?
Detective Stoll.
Okay, and are those part of the extraction?
Yes, ma'am.
Okay. And so when you create your report, do those come from the extraction into the Cellbrite report?
Yes, ma'am.
And do you need the actual cell phone, in this case, CF6134, in order to use another detective's extraction to then take that information or that data and put it into a readable format to the Cellbrite report?
I do not need the phone, no, ma'am.
And why is that?
Because the extraction is the phone, so that's all I need.
All right. But you did verify that the information that you are providing in your report, the Cellbrite report, is the same hash number, which is a hash number similar to what we consider like a serial number, in computer terms?
More or less, more like a signature of the file.
Okay, but it's the exact same number as the number that Detective Stoll came, I guess that resulted from his extraction.
Yes, ma'am.
Now, if you would, I think you did it before I approached, but if you'll explain to the jury then how you take in this case, the extracted data from the cell phone from Detective Stoll and create the Cellbrite report.
Okay, so there's a program that Cellbrite has called Physical Analyzer. So I take that extracted data that's really unreadable by us, and I put it into Cellbrite Physical Analyzer, and that processes the data. It goes through all the databases, goes through every part of the phone, and parses it into readable data that we can understand. The text messages, phone, pictures, videos, call logs, anything that was on the phone is now readable through that report.
And without plugging that extracted data into a readable report, Cellbrite, would anyone be able to read that data?
No, ma'am.
Your Honor, may I approach?
Yes.
I'm going to show you what's been marked as State's Exhibit 374 and 375, and tell me if you recognize these two discs.
Yes.
Okay. And how is it that you recognize them?
Those are the discs that I made, or that were copied.
Copied from what?
My initial report, sorry.
All right. So State's Exhibit 374 is the full extraction of CF6134.
Yes.
And then State's Exhibit 375 is what's labeled tags from CF6134. Is that right?
Yes, ma'am.
Okay. And what is the difference then between these two exhibits? State's Exhibit 374, the full extraction, and 375, the tags from the same cell number, CF6134.
So I will provide usually the detectives if I analyze the report, I will provide a full extraction that has everything, nothing excluded, everything on the phone goes to that detective. If I'm also tasked with analyzing the data, I will tag certain things that are relevant to the case. And in this case I did, so I tagged certain items. And in that case I provide a secondary report of only the tagged items because, if we were to print out the full report, it'd be 30,000 pages or something like that. So I condense it to make it easier for people to view and go through quickly, and with only the tag stuff. But I include both, so everybody has, there's no saying that something's excluded. Everything is there.
So everything from the defendant's phone is under State's Exhibit 374?
Yes, ma'am.
Okay, and then for purposes of presentation in court, State's Exhibit 375 has, I guess, pertinent or relevant information pertaining to either the time period or the facts surrounding the case or rulings made by the court.
Yes, ma'am.
Okay. Your Honor, at this time the state moves to introduce State's Exhibits 374 and 375.
Have you approached one?
Yes.
Well, Judge, there's a ruling that 374 is admitted and
Correct.
and not 375, not 374. 374 is not admitted and 375 is admitted.
The other way around, right?
Correct. 375, Judge, your ruling was 375 is admitted, and 374 is not. However, there are going to be contents of it that I'm going to question the detective about.
And we'll stipulate that they come from 374.
Right. You got it.
Okay, so Detective Knox, then looking at State's Exhibit number 375, State's Exhibit 375, the tagged report. It has your name, is that correct, on what we're looking at?
Yes, ma'am.
Okay. And then underneath it, it has the evidence number, CF6174, the same, that's associated with this LG cell phone.
CF6134.
I'm sorry, 6134, which is associated with the serial number 512CYFT348819.
Yes, ma'am.
And if you could explain to the jury what we're looking at.
So this is a program that is provided along with my reports called Celebrite Reader. When the detective or the investigator that requests this information gets it, they open it up. This is the opening screen. This shows the extractions that were taken, in this case from Detective Stoll, and inputted into this program, and that's where all this data was generated from. This file right here is the physical of the phone. That is the single file I was referring to earlier. And then this is the images that Detective Stoll took, and this is the SIM card, which is the little card that goes into your phone that identifies your phone number and who you are on the network.
And so what is the difference between a logical and a physical?
The physical extraction done by this phone is every piece of data on the memory, from it's all the zeros and the ones, the whole thing. The logical does not include everything, it's just user accessible data.
So, but both of those are on the full extraction reports. Is that
Correct.
right? State's Exhibit 374?
Yes, ma'am.
Okay. And so this tag report we're looking at, State's Exhibit 375, were you able to tag, or did you tag various items on the phone that identify the owner of the phone?
Yes, ma'am.
And could you show the jury this?
So the first thing I did when opening up this is I went through photos. So if we go down here and click on images, let me just... So these photos, anything I went through all the photos of the phone, and I found anything that was what we call a selfie, a picture of the person taking a picture of himself, any driver's licenses or any pieces of paper with their name on it to identify them and say that that is their phone.
So looking at the first item that's shown, is that one of the identifying pictures?
Yes, ma'am.
Okay, a selfie of the defendant?
Yes, ma'am.
Okay. And does it say on the right-hand column when that picture was taken?
Yes, so it was created on 6/2/2016 at 9:55 a.m.
And then if we can kind of look through the other items of identification that you tagged.
Okay, so this is Otis McKane's driver's license, created on 6/17. This is an insurance card with Otis McKane's and Sandra McKane's on there. Then below that, it has the vehicle information, the Mitsubishi Galant 2011 with the vehicle identification number. You keep going, this is a buyer's tag for that same Mitsubishi Galant. Another picture of the driver's license, more insurance card information. And then another buyer's tag receipt for that Mitsubishi Galant. And then just more pictures.
Okay. And so the pictures that you're showing us, the last two you clicked on, one was from June 2016, and this one that we're looking at is April 25th of 2016?
Yes, ma'am.
Okay. And these are selfies of the defendant, Otis McKane?
Yes, ma'am.
Okay. And so you tagged multiple ones, is that correct?
Yes, ma'am.
And so what is the purpose of the identification, whether they be photos or other items that you tagged and placed under the identification folder?
It's just pictures to show and data to show that this is most likely the defendant's phone. It would be very hard for somebody else to have all of this data on their phone.
Okay. And did you, when you looked at the full extraction, I mean, the tags are a small number of whether they be images or searches or phone calls or texts compared to the full extraction report. Is that right?
Yes, ma'am.
Okay. And when you reviewed the full extraction report, were there any other identifying, was there any other identifying information that led you to believe this was any other individual's phone but Otis McKane's?
No, ma'am.
Was there also a email address that's associated with this phone?
Yes, ma'am. So I also tagged that as well. It was an email from Otis McKane 001 at gmail.com, and it was sent from this phone as it identified here in the folder. And the subject says, "Hey Selena, this is Otis. I can't wait to meet you."
Okay.
And that was sent on 6/10/2016.
And were there other email addresses, email messages from this phone under the account of Otis McKane 001 at gmail.com that you found on the full extraction?
On the full extraction, yes.
Okay. Were there anybody else's email addresses associated with this phone to another name besides Otis McKane?
No, ma'am.
So after looking at the identification images and the email address, what other analyzed data were you able to extract and then tagged?
I tagged more photos. I'm sorry. Can you repeat that question?
Okay, so you go through and there's various, obviously on the left side there's analyzed data. So we went
Correct.
through the identification
Okay,
photos,
yes.
right? And then we've gone through the email that's associated with this phone. Did you also tag images?
I did tag images. Other than identifying information, I tagged photos that were relevant, that I thought were relevant to this case.
Did you also tag various phone calls coming in and out of the phone for the period of all the phone calls on November 20th, 2016 and November 21st, 2016?
Yes, ma'am. I also tagged those.
Can we take a look at the phone calls, please?
Yes. So starting at 11:20, the first phone call made on 11/20/2016 was at 12:17 a.m. And this column right here will signify if it is an outgoing call. You know, the arrow is going out, and then this is the arrow coming in, meaning it was a received call. So these are various calls to and from this phone. If it has a number, that's because it is not saved. A name is not saved in the contact information. So in this case here, he has this phone number saved under George. That is on his phone. It has nothing to do with the cell phone provider or anything else. He can name that whatever he wants, attach it to that number.
A contact, is that correct?
Correct, it is a contact.
So looking at the top of this page, the very top one, there is
Sorry, this one.
on November 20th, 2016 at 12:17 a.m. The phone doesn't have the incoming or outcoming arrow. What does that mean?
It just wasn't a valid connection. Its status is unknown. It doesn't know if it was answered or what. It's in the database, the call database, so it's included.
Okay. So then going down, the next call on November 20th, 2016 is at 1:26 p.m.
Yes, ma'am.
And it says for 1 minute and 53 seconds.
Yes, ma'am.
And the number, it's a call from the defendant's phone to area code 346-900-3385.
Yes, ma'am.
Okay. And do you know who, from your investigation, do you know whose phone that belongs to?
Yes,
Okay. And whose phone is that?
Christian Fields.
Okay. And do you know Christian Field's connection to this case through the investigation?
She's married to Otis McKane.
All right, and so that was on 3/20/2016 at 1:26 p.m.
Yes, ma'am.
from the defendant to Christian Fields.
Yes, ma'am.
Okay. And then beneath that, there's another call from the defendant's phone to that same number.
Yes, ma'am.
Okay. And what time is that call?
2:35 p.m.
And how long is that call?
It is 41 seconds.
All right. And then there appears to be a call underneath it. Is that right? At 210-574-9545 at 2:38 p.m.
Yes, ma'am.
And then it indicates whether the call is answered or not, right?
Correct.
So the ones where there's not a phone in the column that has the blue arrow going in or the green arrow going out, and if it says unknown in the status, they seem to correspond. Is that right?
Yes.
Okay. So then he the defendant received a call at 2:38 p.m. from 210-574-9545.
Yes, ma'am.
Do you know whose number that is?
That is Sandra McKane.
Okay. And it was for a minute and 57 seconds.
Yes, ma'am.
And then again on 11/20/2016 at 2:45 p.m. And it looked like it was a 5-second call that was answered. The defendant called who?
Christian Fields.
And then on going down that same list on November 20th, 2016 at 4:03 p.m. There's a call for a minute and 45 seconds. And who is that call from?
There's a call from George, or somebody identified as George.
And then going down about 17 minutes later on the same date at 4:20 p.m. For a minute and 5 seconds, there's a call from 346-900-3385 to the defendant. And who was that call from?
Christian Fields.
And that's at 4:20 p.m.
Yes, ma'am.
And then at 5:29 p.m., and all these right now are on November 20th, 2016, there's a call from George again.
Yes, ma'am.
And how long did that call last?
That call lasted 56 seconds.
And then there's a call at 5:35 p.m. on the same day from 210-557-0915.
Yes.
And how long did that call last?
A minute and 59 seconds.
And do you know whose number that is?
I don't.
So then going down, there's another call then. It seems to be multiple calls coming in. Is that right?
Yes, ma'am.
On November 20, 2016, 5:37 p.m., a minute and 18 seconds. And it's from 210-982-2354.
Yes, ma'am.
Okay, and was that call answered?
Yes, ma'am.
And then underneath it, a different number came in at 5:49 p.m. same day, 36 seconds answered from 210-719-8934. Is that right?
8933.
Oh, I'm sorry. Okay. And then at 7:46 p.m. there's another call that's coming in from 210-776-0663. And that, how long did that call last?
A minute and 44 seconds.
And then there's two calls kind of from a different number, 210-914-2103, kind of back to back at 7:48 and 7:55 p.m. But it's unknown whether or not those were answered. Is that right?
Correct. Yeah, it is unknown if they were, the defendant attempted to make the calls or they were attempted to receive the calls. It's just, there's no data on it.
Okay. So it's not clear that the call came from his phone or the call came from another individual's phone to the defendant.
Correct.
So then there's a call from Simone at 8 p.m. for a minute and 51 seconds, and her number is 210-643-3093.
Yes, ma'am.
And then that appears to be the last call of November 20th, 2016.
Yes, ma'am.
And then there are, if you can tell us about the next call then.
Next call was not answered. That's on 11/21/2016. That was at 6:08 a.m.
And is that a call that was coming from the defendant's phone?
Yes, coming from the defendant's. He made that call. It was not answered.
All right, and then that was 805-637-7234. underneath that, there's another call that he made at 6:08 a.m. And again, now these last two are on November 21st, 2016.
Yes.
And what was that number that he called?
210-980-5417.
Okay. And do you know whose number that is?
No, ma'am.
Okay. And then on November, and then same day, November 21st, 2016, at 9:20 p.m., I'm sorry, 9:19 a.m. One up, please.
919. Okay, there we go.
It's a number, it's a call that is 7 minutes and 17 seconds. 210-574-9545. And do you know who that call, that number goes to?
No, I don't.
Okay. And that 210-574-9545.
Oh, sorry. Getting confused here. Yeah, so that's Sandra McKane. That's his mom.
And that's 7 minutes, is that right?
Yes, ma'am.
On 919, okay. And then there's, from another call's coming in, 346-900-3385.
Yes, ma'am.
And it looks like it's 6 seconds. And is that
That's Christian Fields'
Christian
son.
Fields' home? Okay. And so how do we have two numbers where one of them, he's speaking to someone for 7 minutes and then a minute later speaks to someone for 6 seconds? Is that a call waiting? Is that what that would indicate?
He could have, yes.
Something like that, okay. And then again, there's another call at 9:52 a.m. from Sandra, we don't know if it's from her or to her, Sandra McKane?
Correct.
Right? Okay, and then same date, November 21st, as we scroll down, another call to Sandra McKane,
Yes, ma'am, for a minute and 5 seconds.
and then at 5 seconds at 10:38 a.m. And then there's other calls that are coming in at 10:32 a.m., is that right, for 8 minutes?
Yes, ma'am.
936-648-0876.
Yes, ma'am.
Okay, and do you know whose number that is?
No, ma'am.
And then there's another call for 3 minutes and 38 seconds at 11:04 on 11/21/16. And do you know who called the defendant?
That's Sandra McKane again.
And then there's another call at 11:12 a.m. again on the same date.
Yes.
A minute and 50 seconds. You don't know who that one is that right?
No, ma'am.
Okay, and there's 3 more. 2:34 p.m. Another call. Looks like 4 seconds. 2:51 p.m. for 56 seconds. Another call. And then at 2:55 p.m. For a minute 33 seconds. Again on the same date, November 21st, 2016, from 210-574-9545. And who is that call?
That's Sandra McKane again.
Okay, calling
Calling Otis McKane.
Otis McKane. Okay. All right. So let's go to now the instant messages. Did we do that?
Okay, so on this, it tags the entire chat. So you can see here with the bubbles, I tagged 3 different chats and 3 different numbers. The first one is 1 text, the second one is 18 text, and the last one is 5.
And on the right column, when it says owner in parentheses, and then beneath it, it says Simone, what does that mean, owner in parentheses?
So owner is the phone. It's from the phone, or the phone.
Okay. And then, so if you can click on the first one and go through that, please, to Simone.
So it was just a single text to Simone with the phone number of Christian Fields. And it says, Christian is my fiance, call and keep in touch. And that was sent on 11/20 at 8:05 p.m.
11/20/2016?
Yes, 11/20/2016.
Okay, at 8:05 p.m. to Simone from Otis McKane.
Yes.
And so then it lists Christian Fields' number, is that right?
Yes, ma'am.
And then the
Can we approach you on the briefing?
Yes.
Objection.
may be seated.
I'll let y'all look at them.
So, take notes if you want to, if you want to, can we?
17 CR 1505, State of Texas versus Otis McKane. Present in the courtroom are attorneys from both sides as well as the defendant. The jury is not present. Counsel?
So it's the state's position on this communication, these text messages from the defendant to Christian Fields, that the defense waived the objection when we introduced this State's Exhibit 375 into evidence and didn't object to that specifically. Additionally, the defense has the burden to prove that they are common law marriage, and so they haven't put on any proof of that. These text messages, we've reviewed them outside the presence of the jury with the defense, and the last text message that is sent is on November 20th, 2016 at 2:27 p.m. between the defendant and Christian Fields. That's the last one she sends to him, which is prior to the two of them getting married the following morning on November 21st, 2016, around 10-something a.m. And then finally, Christian Fields waived that privilege when she told Detective Duke that you can search my phone. She gave consent, and the court had an opportunity to view her DVD statement to Detective Duke in regards to that.
When she agreed to talk to Detective Duke, Your Honor, also about what they did that day. We're arguing there is no privilege, they've got to establish it, but even if you believe there was a privilege, she clearly waived it when she agreed to talk to Detective Duke, which the court has seen the video of, about the events of that day.
Would you stand on the objection, would you send it to the court earlier?
All right, so anything, currently anything after they came to the courthouse and got married, what is it, 11/21, 2021, 10-something in the morning? Anything after that, I'll take it out. Anything prior to that, based on the evidence I've seen, I'll overrule the defense objections.
So I can just tell you, Judge, for this right here, it ends at this time. I don't know if there are others because I didn't view it with that in mind. So do you know if there's others that are between them?
I said, where's number 30? Ask him, I think you know.
I don't know if he has it.
No, I would have tagged everything.
Yeah,
and then, so that's the last text, because I've tagged the entire text thread between the two.
This is like the invite.
Yeah.
That's it.
I'm looking at everything he's got listed here. I don't see any more.
So I just want to point that out. If something inadvertently comes, then I'm not aware of it in my mind. But we can also, if we see the number, we can take a break.
Sure.
Okay.
Sounds good.
That's right.
All right, let's go ahead and bring in the jury.
Can you scroll to the, or go back to the top?
Scroll up. Let's
Go to
start.
the top one. Right where we left off. Thank you.
For the jury?
All right, welcome back, members of the jury. State, you can continue.
Thank you. Detective Knox, so we left off going through the first text. And just so the jury understands, these text messages, there are multiple other text messages on the full extraction report, correct?
Yes, ma'am.
Okay. That do not relate to November 20th and November 21st of 2016.
Right. So as I explained earlier, the full report contains everything, but then I have this condensed report so it doesn't have everything. It's
Doesn't have
easier
months
to-
and months and months of text.
Correct.
Okay. So then, but the text messages that the jury is seeing is every text message that was sent beginning, I guess every text message that has a November 21st, 2016 or November 20th or 21st, 2016. Is that correct? And then the string goes back if there is a string.
Yes, ma'am.
Okay. So looking at the, so the one to Simone is just the one text giving Simone Christian Fields his fiance's telephone number to keep in touch. Is that right?
Yes, ma'am.
Okay. And then that's at November 20th, 2016 at 8:05 p.m. The second number, if we can take a look at that string, the 18 represents what, sir?
18 messages back and forth between the two devices.
Okay, and this number, the 346-900-3385, you've testified that that number belongs to him,
Christian Fields.
who is the defendant's wife as of November 21st, 2016.
Yes, ma'am.
Right. So looking at these, where do these text messages begin here?
This starts on 11/13/2016 at 7 p.m.
And you can just, if you can kind of read through these messages, please.
Okay, so she sent him a text that says, "I got something for you." Then she sent another text. Says "with" is a correction.
Okay. And then the next one, I think the jury can read that. November
Yes.
26, November 16, 2016. Okay, what home?
Yeah.
At 1:03 p.m.
Yes.
Telling him not to
Mess with nobody.
Right, in a different with other
Yes.
words, right?
Correct.
Okay.
And then on 11/17/2016, he sent "wake up" for me. And then
So the greens are coming from the defendant's phone, and the blues are coming from the, in this case, Christian Fields' phone.
yes, ma'am.
Okay.
Then a text at 11/17 at 7:20 a.m. "What's up, Daddy?" And then a text that says "cookies." And then a text, "Where you at?"
And that's on November 18, 2016, 5:41
Yes,
p.m.
5:41 p.m. Then a text from Christian Fields at 11:18 at 10:08 p.m. that says, "I made some hamburger helper. You can have some." Then there are two more texts. These, when it looks like this, it means there's an attachment to it. So there's no text with it, but there is a picture. I think this is when it opens up on the other screen. It's hard, because this setup is two screens, so I only get to see this screen. So that picture opens up. There it is. She brought it over for me. Okay, so that's the picture that Christian Fields sent to Otis McKane's phone.
Okay, on November 19, 2016.
Yes. I just need to get back to the report. There we go.
Right.
Okay.
And that's at 9:54 a.m. So we'll go to the next one.
You're fighting me with the mouse. Okay. So same thing. It's another text, same picture.
Just a few minutes later.
Yes.
Okay, and then on November 19, 2016 at 12:56 p.m.
Yes. It says if you wasn't go come, you could have just let me know. And then another text says, "Are you on the way?"
Same on November 19, 2016, 12:43 p.m.
Yes. That's the way this. And then a text from Otis's phone that says, "My fault, but I'm going to take you somewhere when we get off." That was on 11/19/2016 at 3:35 p.m. And then another text Same date, 3:34 p.m., what time you get off. And then on 11/19/2016 at 5:10 p.m., text as soon as you get off so I can get you. Then one more text on 11/19/2016, 9:04 p.m. Sorry, had to drop off my sister. I tried to call you, but your phone off.
Okay.
And then she responded on 11/20 at 12:59 p.m. You all right?
Okay.
And then
she sends him an additional message.
yes, at 2:27 p.m. on the same date, I got 2 more movies from the Red Box for us.
And
Yeah,
these last 2 are from Christian Fields to the defendant on November 20th, 2016. One at 12:59 p.m. asking, you all right? Or saying, you all right? And then the second one about an hour and a half later saying that she got 2 movies from the Red Box for them.
Yes.
And did he respond to any of these texts on November 20th, 2016?
No, ma'am.
And did he have any text to her any point after this through November 21st, 2016?
No, ma'am.
Okay, so let's go to the last grouping that you tagged between the defendant and George.
And this says 5 texts. Otis McKane's phone sent out a text. Says you still at the booth. That was on 11/11/2016 at 11:59 p.m. Then on 11/12/2016 at 12:23 is a response from George that says on the west, drop at SAP off. Then on 11/16/2016 at 6:47 p.m. Otis McKane's phone's texted till what time. And then again on the same date at 6:55 p.m. it says when y'all get on the booth. And then on 11/20/2016 at 7:52 p.m. A picture was sent to Otis McKane. It appears to be from a Facebook post from Jose Cruz Amaro. It says, suspect involved in the murder of SAPD officer today, please share.
And so it's a picture of the defendant and his vehicle, is that correct?
Yes, ma'am.
Okay. And so this picture was sent, or this Facebook post was sent as an image from George's phone to the defendant?
Yes, ma'am.
And you said it was on November 20th, 2016 at what time, please?
7:52 p.m.
Okay. Now, do you know, looking at these messages, if an individual had deleted messages, would they show up?
Yes.
Okay.
Sometimes, not all the time. Sometimes they will show up. In this case, because it was a physical extraction, it was able to recover some deleted stuff, but there were no deleted texts during this time.
Okay, thank you. So let's look then at the, so we went through, what is this? This is the chats, is that correct?
Yes.
Messages. Let's look at the, what else do we have that you tagged?
He searched items and searched in web history, and we also have important images.
Okay, let's look at the web history then. So again, the web history, starting with November 20th. Can you tell the jury about what you're looking at, or what they're looking at?
Okay, so this categorizes everything as far as web history goes. When it was last visited, the title of the web page that they visited, and the URL that they visited. So these are the times when they're extremely close together. It doesn't necessarily mean that he did 2 exact searches for that. It's just that's the way the phone stored it. So the first one, on 11/20/2016 at 5:34 p.m., he went to ksat.com, and the title of that page was Officer Shot Killed Outside of SAPD Headquarters. And that was done using the Chrome browser.
Okay, and so can you tell the jury about Chrome browser, what that means, or what that is?
So he had an LG phone, which is an Android OS, and so the default browser for that is Chrome, just like Safari is the default for an iPhone.
Okay, and so when an individual, so it shows the date and time that the search was made using Chrome?
This is the visited, yes. So,
Visited, I'm sorry, visited.
yes, and so in this case it was 11/20/2016 at 5:34 p.m.
Okay. and the two that are kind of close in time?
So that's visit at 5:33 and 5:34, which are really close. And then the next one is at 4:06 p.m.
So it was earlier then,
Yes.
right? About an hour and a
Yes.
half earlier?
So the way that this is organized is latest to the earliest. So
And so then the other two, both at 4:06,
On
which you said
11:20.
could be the same search, right?
yes, on those two, yes.
Shows, and is there any difference between these searches?
No, they're both to the KSAT website for that same article. Officer shot and killed outside of SAPD headquarters.
And so these new searches that you're seeing, you had an opportunity to review all the searches for that time period. Is that, I mean, actually you can go back as far as on the
Yes.
phone, right? But are there any other new searches going on at this time period besides this particular search for the officer shot killed outside SAPD headquarters?
Not that I'm aware of.
So then the next one, so then there's a series of searches on November 12th, 2016.
So
Can you tell the jury about that?
This first one, 11/12/2016 at 8:46 a.m. is a link to a YouTube video. There's not much detail directly with this entry, but at the exact same time as another entry for a YouTube video talking about Glock disassembly and how to field strip a Glock, which is basically taking the weapon apart. So
And what's
there's
the purpose of taking a weapon apart or field stripping a weapon?
we would field strip our weapons to clean them.
Okay. All right. And so then the next group of searches?
So 841, and so this, there's no title, but this, being that it's google.com, you can look at the actual URL. It might be easier to do it. Let's see. And this indicates that it was actually a search, because the way Google lists a search is anything after the search $G equals is what the user actually typed in. So the user typed in on this phone, how do you take apart a Glock? And so and then it was a search on google.com.
And are there, let's look at the dates and time, please, of how to take apart a Glock.
It was on 11/12/2016 at 8:41. And so again, they're all relatively close in time. So it's just the way the phone stored the data that it probably wasn't that many searches. It could be that it's just storing it as he's typing it. It's not really clear. And then on 11/12/2016, 8:41 again, how do you take apart a Glock? And then prior to that, on 9/15/2016 at 11:47 a.m. There's searches for hotels, Austin, North, Round Rock. Again, related to Austin, Round Rock Sports Center.
Okay.
And just below that, on 9/15, the same day, 11/26, Round Rock Sports Center gun show.
Okay. And then after that are the, on 9/6/2016, the rent-a-tire searches, is that right?
Yes, searches for rent-a-tire, the rent-a-tire location at 813 Bandera Road. Another search for rent-a-tire, and then Goodyear near me.
And now can we go to the images, please?
Just one more. Should be. So this is the search terms. Those are visited websites, and so again, 11/12, the search for how to take apart a Glock.
And let me ask you before you move on. You said, one reason someone would take apart a Glock is to clean it. What's another reason to take apart a Glock?
You want to.
Object to speculation.
Well, he's a police officer for 15 years, Your Honor.
So only respond if you know.
I couldn't say why somebody would take it apart. The only reason I would take mine apart is to clean it.
Okay. But you're a police officer, right?
Yes.
Okay. So let's go through these then.
Again, how to take apart a Glock, the Round Rock Sports Center gun show, rent-a-tire. This is the GPS coordinates for the rent-a-tire.
Like from Google Maps or something?
Yes.
And
So yeah.
Oh, go ahead, I'm sorry.
Basically the same thing, but it's just the searched stuff.
And so what's the difference between this screen we just looked at and the previous screen?
It's just the way the phone categorizes it. Sometimes it shows up as a searched item, and then the others are visited in the web history.
So if we can look at the images that you tagged. So if you can go through these, please.
Okay, so this is a picture of the SAPD badge with the black stripe around it, which we wear whenever an officer is killed in the line of duty.
So are you able to tell by looking at this when this image came onto the defendant's phone?
So this image, no, we are not able to tell when this came onto the defendant's phone or when it was put on there. And the reason because it was done through Chrome, but it was stored in the cache, and so the cache doesn't store that information. The next one is a news headline from KSAT.com, specifically gunman who shot at SAPD headquarters sought. That was accessed and put on the phone on 11/20/2016 at 4:06 p.m.
And the
Patrol,
third image?
patrol car, again, no information when it was put on the phone. This is an image from WikiHow on how to dismantle a Glock. This is just a picture of a Glock from that website.
And again, and so if there is a date, whether it's the date that it indicates created, access, will you state that?
Yes, I will.
And otherwise, if there's not a date on the right column, what does that indicate?
It's just stored in the cache, and we don't have any knowledge of when it was on the phone, when it was accessed. It's just the data's not there. This is a picture of the top slide of a Glock. Another image of a Glock. It's a picture of Detective Benjamin Marconi's end of watch image that was displayed. Looks like headquarters. 11/20/2016. 20 years of service.
And so looking at this, there's no date, access, or is that correct?
Correct.
Because he looked at it on cache?
Well, he looked at it on Chrome, but this image was stored in the cache. So there's no metadata attached to it. Another picture of a Glock. Picture of a Glock. Another picture of a Glock. Glock. A Glock. Picture of what appears to be somebody field stripping a gun, a weapon. Same thing here. They're field stripping. Another field stripping of the gun. This looks like somebody's cleaning a gun that's already been field stripped. These two images are the same. They're ones from Ray Saldana. SAPD officer lost his life in the line of duty this afternoon. Our thoughts and prayers are with the family during this difficult time. And then another from Ivy Taylor. My deepest condolences to the family of officer killed today and all SATX police. This type of crime cannot and will not be tolerated. So that, again, we don't have any data when that was actually put on the phone. Another picture of a Glock. This appears to be a man shooting a gun or holding a gun inside of a firing range. Here's one of a man holding a gun inside of a gun store. Picture of somebody loading a magazine into what appears to be a Glock. This is a picture of a man out on, looks like a outdoor shooting range holding a Glock. Another picture of a Glock. This is one with the slide lock to the rear of a Glock. It's a picture of a man holding a Glock. This one appears to be someone has completely disassembled a Glock. Another one of a slide. Another picture of a Glock. This is a graphic of someone, it looks like they're pulling the slide back, or in the process of it, to lock the slide to the rear. This is another piece of a Glock. Picture of a Glock. Picture of a Glock with the text Glock cleaning and lubrication. Here's a picture of a Glock that looks like a knife attached on the rail. Picture of a man firing a Glock that protects Glock meltdown. Picture of a guy holding some sort of weapon inside of a firing range. This is a side view of a Glock and its internals. Oh, sorry. Oh. There's a picture of a Glock with rounds and somebody loading it into a magazine. Picture of the trigger of a Glock. Picture of a Glock, two Glocks actually, one with the rail off and one, the slide off and then the Glock, another Glock. Here's a picture of someone holding a Glock. Another picture of a Glock, just a different type of it. This looks like barrels to what I would assume is a Glock.
And what is that?
The barrel is the piece inside of the slide that the bullet is actually shot from. Here is another picture, someone holding a Glock. Picture of a Glock, two magazines, two individuals looking over a Glock. And here is a picture of public safety headquarters, and it looks to be the day of the shooting. There's crime scene tape. I think I can make this bigger. There's Detective Marconi's vehicle. There's the vehicle that he had stopped, and police had blocked off the entire area.
And there's two pictures, is that right, kind of back to back?
Yeah, there's actually three.
Three.
Doesn't mean that they were looked at three different times. It's just that's the way it was stored on the phone. Could be. It looks like they were possibly different sizes.
Different what, I'm sorry?
Different sizes.
Okay. And what does that tell us? Different sizes?
It's just it could possibly be the way the phone stores the data. Could for viewing, a smaller size, the easier to view on the screen versus a bigger size. This is the photo we saw earlier. This came from that text message, which is why you see the little attachment symbol here.
The one from George at 7:52
Yes.
p.m. Okay.
And this last photo is a picture of the defendant's car driving through the south parking lot at public safety headquarters. And so those are the pictures that I tagged during that day that I felt that were important.
Okay. And what about videos?
There are. It opens up. Oh man. There it is. Okay. So there's 4 videos tagged in here. The sizes are small, so it is not the full video, but it could potentially be just like a little snippet of the video to show you what it was. They all pertain to a Glock. This one is a video of a gentleman pulling a gun out of a concealed carry holster out of his front pocket. The rest are just videos of Glock.
The other 3 are just
Yes,
videos
the other
of
3.
Glocks.
And they only play the first second or two because they're tiny.
Okay. And what does that mean, they only play? I mean, do they give you to a link, like a YouTube link or some other link that's connected that an individual is able to watch it? Are you not
No, you
clicking
can't
it?
click on the, they're not links, they're just little snippets of video stored on the phone.
Okay. Did we go through, is there anything else?
I think the only thing I haven't covered was the user accounts to identify that I had tagged. So I tagged these because the name is listed as Otis McKane from the Gmail email account, Otis McKane 001. And this last one down here again lists his name as Otis McKane with his phone number, and this is from the Uber app.
Okay. And so the last one with the Uber app, it has ODIS McCain 001 at gmail.com, and then it has with the Uber app this same telephone number, the 210-980-5417.
Yes, ma'am.
Okay, and that's this particular phone that the jury's looking at the Cellbrite report from the extraction.
Yes, ma'am.
And
And the tag for Sandra McKane, that I tagged every call that she made, or to and from them, but I think we already went through the call logs.
Okay. Your Honor, Mayor French?
Yes.
So, Detective Knox, then, on the full extraction, there were multiple text messages, right, pertaining to other either events or other conversations. Is that a fair statement from the full extraction, States Exhibit 374?
Yes, the full extraction has a lot more text messages that I did not tag.
Your Honor, Mayor French?
Yes.
So I'm going to show you what's marked as States Exhibit 377. Do you recognize, take a moment, I know you've had an opportunity to look at States Exhibit 377, haven't
Yes,
you?
I have.
Okay, prior to getting on the witness stand.
Yes, ma'am.
Okay, and are this stack of text messages, are they from various numbers to the defendant's phone?
Yes, ma'am.
Okay, and that's that phone, that's the 210, is it in front of you, 9, for the record, 980?
5417.
5417, okay. And so do these text messages back and forth from various individuals to the defendant and from the defendant to these individuals, they are stapled together in groups of the text messages?
Yes,
of the actual conversation?
Yes.
Okay. And are these messages from the full extraction under States Exhibit 375?
Yes, ma'am.
All right. And, all right. And I'm also going to show you States Exhibit 381. Do you recognize this?
Yes, ma'am.
Okay. And this picture that's in this, not just the picture, but so it's an image, and it's also a, how would you categorize this image? As a particular search, or?
It was just an image that was on the phone.
Okay, an image that was on the same phone we're talking about,
Yes.
the defendant's phone. Okay, and does this particular image, States Exhibit 381, did that come from the defendant's phone that you've been testifying to, from the full extraction report?
From the full extraction, yes, ma'am.
Okay. Your Honor, this time the state moves to introduce States Exhibits 381 and 377. For the record, the full extraction is 374.
Can we approach it separately?
Yes. Correct, it's admitted.
So, Your Honor, may I publish it to the jury?
Yes.
So looking at State's Exhibit 381. So again, this is from the, an image that you found on the defendant's phone from the full extraction, is that right?
Yes, ma'am.
State's Exhibit 374, and this is printed and it's labeled State's Exhibit 381. Are you able to see that in front of you?
Yes, ma'am.
Okay. Can you tell, so you said this particular image, the photo of the police officer was on the defendant's phone, is that right? This image?
Yes, ma'am.
It's listed as a thumbnail, is that right? You see at the top, it's under the category of thumbnail?
Yes. That's a thumbnail of the image.
Thumbnail of the image, right? Okay.
Right.
And so are you able to tell us some information about this particular image?
Just, again, the created date says 11/13/2016 at 4:58 p.m. Those are two different images because image one, the size is 13,134 in bytes, and the second image, the size is 34,060 bytes.
And what is the significance of this image, or why would this be something that that you would either tag or did you look into this particular image?
So that is a picture of a sheriff deputy from California that was killed a few days prior to Detective Marconi being killed.
And that was on the defendant's phone, this
Yes,
image?
ma'am.
Looking at State's Exhibit 377 that you have in front of you, I just have a few follow-up questions on it. Thank you.
You're welcome.
Now there's some, if we go through these text messages without reading the content, there's some markings on it. Some of them have in the corner a circle with a red X. Do you see that?
Yes.
Okay. And what does that indicate?
That indicates that that message was deleted from the phone.
So all the ones with the red X would have been deleted,
Yes, ma'am.
but they were able to be, I guess they were able to be found, recovered, right? Once through the extraction?
Yes, ma'am.
And so if there is not a red X, what would there be?
Just there wouldn't be anything right there where that X is, and it just signifies that that text message is still on the phone. If you were to turn the phone on and look through his text messages, it would still be there. But,
If it didn't have the red X?
correct. If it has the red X and you turned the phone on and looked, you would not see those messages.
Okay. It's only through the full extraction that you're able to, these messages are able to be recovered, is that correct?
Yes, ma'am.
Okay. And so again, kind of similar to the ones that we showed the jury on the screen, the green squares on the left side come from whom, and the blue squares, the green side on the right side come from whom, and then the blue squares on the left side come from
No, come from somebody else.
whom. Okay, so that's what I'm asking you.
Yes, so the green side is from the defendant's device, and then the blue side is a received text to that device.
Okay. I'll pass the witness.
Thank you. You're excused. All right, State, call your next witness.
State calls Kyle Williamson.
What was the last name?
Williamson.
Thank you.
Judge, may I approach?
Yes. You can have a seat. I'm going to swear you in. Yes. Do you solemnly swear or affirm that the testimony you give in this trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can adjust the microphone, make sure everybody can hear you. If you could introduce yourself to the jury and spell your name for the court reporter, please.
Yes, my name is Kyle, K-Y-L-E, Williamson, W-I-L-L-I-A-M-S-O-N.
All right, State.
Good afternoon, Sergeant. Can you please tell us what you do at SAPD?
Currently, I'm a sergeant with the SAPD Narcotics Unit,
And how long have you been with SAPD?
approximately 22 years.
And what other kind of roles have you had at SAPD since you've been with them 22 years?
Just like anybody else, start off at patrol. Did patrol for several years as a patrolman. Then I went to the SWAT team. I was on the SWAT team for approximately 5 years. Got promoted to detective. I spent, I believe it was 3 years, approximately as a detective. Majority of that was in the narcotics unit. Once I got promoted to supervisor sergeant, I spent a short time on patrol, approximately 5 years in the game unit, and then now it's close to a little over 6 years in the narcotics unit now.
Can you tell the jury a little bit about what kind of cases you work in the narcotics unit?
Well, we do, of course, narcotics investigations, and we try to, some short term, some long term, undercover buys, street pops, just basically working drugs any way we can, as far as trying to work up to the dealers.
Can you tell us what a street pop is, please?
Just arresting somebody on the street with drugs in their possession. We have different ways of doing it, but just basically popping somebody on the street with drugs in their possession.
And in regards to undercover surveillance and bust, how do you go about doing that?
Well, there's, of course, undercover when we pose as a criminal buying drugs, we'll do that. There's times when we just do surveillance and not necessarily undercover, but plain clothes, watching things. And once we see a drug dealer or whatever, we'll contact those people.
So have you had the opportunity as a sergeant with narcotics to be part of many drug investigations?
Yes.
About how many could you, if you could even guess?
In the thousands. I mean, I would be 90 if I guessed, but in the thousands.
And have you participated in all sorts of roles within those investigations in regards to being on the street, to street pops, to supervising, what have you?
Right. When you first come to the department, you learn pretty quick that a large portion of the violence and things that the crime in the city are due to narcotics in some way, shape, or form. So you learn to kind of target that. At least I did. And so as a patrolman, targeting the drugs, the people selling the drugs and things like that. That's how you try to combat the violence. So on that level, yes. As a detective, of course, the undercover work, the surveillance, the things like that, the search warrants, those angles, working with informants. And now as a supervisor, supervising the detectives that work these cases. So in several different forms, yes.
And as a sergeant with years on the narcotics unit, have you become familiar with the terminology that drug dealers use or drug buyers use when they're talking about buying or selling narcotics?
Yes.
And is that a language that you are fluent in?
I would say I'm pretty fluent, yes.
And also, through your experience, have you had the opportunity to go through drug dealers' phones?
Yes.
And do you look at their text messages?
Yes.
Obviously, from a warrant. And what kind of information are you able to gather off of text messaging of drug dealers with their buyers?
How much they're charging for a product, what product they're selling, just how many people they're selling to, things like that. Whether they're delivering, whether they're picking up, multitude of things like that.
And having so much experience with this, is it easy for you to determine what's going on with a particular person if they're dealing or buying?
Yeah, it's usually fairly obvious once you start reading that text chain or something, what's going on.
In modern times, has it become a useful tool for detectives to look into a individual's phone to determine what they're up to?
Yes.
And were you asked to do that in this particular case?
Yes, it was.
Have we approached her?
Yes. All right, members of the jury, we're going to take up an issue outside your presence. We're going to go ahead and incorporate our lunch break along with that. We don't know how long the hearing will take. To be safe, I'll let you go to lunch until 2 o'clock. All right, so be back no later than 2 o'clock, and we'll continue with this trial with you
All
guys.
right, for the jury. Maybe see it?
What offense, did you want to take them up on board R? Or?
Well, if they just want to get into what the profit evidence would be.
Okay, let's do that.
Were you asked to review State's Exhibit 377? It's in front of the judge, but a series of text messages from Otis McKane's phone.
Yes.
And what were you able to determine when you looked through those text messages?
There's a lot of talk about delivering narcotics, pick up narcotics, how much it would cost, things like that. So the narcotics deals, a lot of it.
Okay. And that is evident by the text messages that you reviewed.
Yes.
About how many different phone numbers was he conducting these transactions with?
I believe it was 34, 35, 36, something like that.
So 34 different numbers, roughly, showed evidence of this defendant, Otis McKane, dealing narcotics.
Yes.
And if you know, how far back did this dealing go?
I believe it was back to April 2016.
And how close up to the time he was taken into custody is there evidence of him dealing?
I got to kind of look through. I got the latest one. November 2016. November 12th. November 10th. So end of November 2016.
And what type of messaging would you see that led you to believe that he was in fact drug dealing?
The terminology of different amounts and prices, the names of the drug, or slang terms of the drug.
And could you determine what type of drugs this defendant was dealing?
I saw some cocaine, and the majority of them were marijuana.
And you knew that because you're fluent in the language, as you told this court earlier.
Yes, ma'am.
And as essentially an expert in narcotics and narcotics drug dealing from all your experience, could you say undeniably that this defendant was involved in drug dealing?
Yes.
Judge, at this time I wasn't planning on going through each individual text because there are so many. If you even look at the front page of Exhibit 77 or 377, it's obvious
Yeah, I can see.
from the nature of it. So at this time, the state would pass the witness.
If I may go on.
Yes.
Sergeant Williams, right?
Yes, sir.
I'm sorry, what?
Williamson.
Oh, Williamson.
Yeah, people
But
forget.
you are a sergeant, right?
Yeah, people forget the O-N all the time. I'm used to it.
I got your rank right.
Yes.
My name's Will Pettis, and we represent Mr. McCain here. So you say you've been in narcotics how long?
As a supervisor, back there about 6 years, a little over 6 years.
Okay. And in this text that you reviewed, first of all, would it be unheard of for one, let's say one drug dealer or drug buyer to have multiple phones, for example?
No, that's not unheard of.
That's
no.
not unheard of, right?
No.
In the exhibit that you reviewed, we know, or at least from what maybe you've been told, it's Otis McKane, or that phone, if you will, communicating with other individuals, this other 34, 36 numbers.
Right.
Okay. And do you know the identity of the individuals at the other end of this 34 or 36 numbers?
The one that he's texting to?
Yes.
No, I don't.
And the people texting back to him, we don't know their identity, right?
No.
Okay. And you don't know if there are, let's say there were 36 numbers, okay, just for argument's sake. We don't know if it's one individual with 36 phones or 36 individuals with one phone.
Yeah, I have no way of seeing.
Okay.
No.
And the state stated that you are an expert in narcotics dealing, let's just say.
Yes, sir.
Right. And they said, and I believe the language the prosecutor used with the judge, if you look at the first page, it's obvious, is what she said. Did you hear her say that?
Yes.
Okay.
I think she was talking to the volume of it, not exactly.
Oh,
That's what I understood. It's
Okay.
obvious the volume of it. That's kind of what I thought she was talking about.
okay. I thought it was to the context. In other words, it's obvious that it's drug dealing, let's just say. Would you say that?
Am I saying that it's obvious what's going on there? Yeah, I would say that, yes.
Okay. But if I read them, would it be obvious to me too?
It may or may not. I don't know your experience, but
Okay.
I think you would probably you'd probably see it if you read them all. You kind of figure it out.
Yeah, and so when we talk about your qualification, let's say as an expert, what would qualify you other than experience? Let's just say.
Training, experience. I mean, like I said, I've been doing this a lot. The majority of my career, and in some way, form or fashion, through several ranks, and mainly focusing on, narcotics specifically. So.
Okay, but what I'm trying to get to, it's not a science, is it? This narcotics busting people, and in this particular instance, the language there, it's not a science, right? It's subjective to the reader.
Based on my history and my experience, man, I can tell you that, you know, from based on my history and experience with this, what I see going on the text chains.
Sure, but let's just say, we know that in narcotics drug dealing, let's say if I was selling kilos of cocaine, I wouldn't say, hey Williamson, do you have those 2 kilos of cocaine? Generally, you don't say that on text or even on the phone when you're talking, right?
Depends how smart they are.
Yeah, obviously, but you'd agree with me that in drug dealing, that's not the norm, right?
Yeah, they usually come up with a different term.
Yeah,
Not all the time. Sometimes they do, sometimes they don't.
Yeah, and sometimes people say, hey, I've got those 2 tires for you. What time can I take them to you? Another
Right.
guy may say, I got those 2 engines, you want them, correct?
Right.
And so what I'm saying is, to a particular reader, you're a narcotics officer. Someone might be selling 2 tires. You see what I'm saying?
Right.
I mean, just from the context of the text. You see what I'm saying?
I understand what you're saying.
Yeah.
It is, unless he's selling a lot of flowers, I don't think too many buds of flowers, for
Yeah.
example,
No, and I understand that. All I'm pointing to you, it's subjective to the readers.
Well, yeah, I get what you're saying, yes.
Okay. Nothing further.
Okay, just, oh, wait, one other thing. You want me to-
And did you say we're using interchangeably the word narcotics? I guess narcotics would be heroin, fentanyl, cocaine, meth, marijuana. Narcotics applies to those.
Narcotics. The word, it kind of encompasses all those illegal.
Correct.
drugs, right.
In this instance, what is the narcotic, if you will, that is being, according to you, dealt?
Mainly marijuana,
Okay.
and I'm seeing a little bit of evidence of cocaine.
Okay, but mainly marijuana?
Right.
And can you tell from the text in what amounts?
Usually it's from ounces to maybe a little bit less, grams, ounces to grams.
Okay, and with regards to your experience in marijuana dealing, would ounces or grams be personal use on marijuana?
Yep.
Okay.
Ounces wouldn't, if you're going to smoke something, it's going to be in grams, not in ounces, but I can buy a kilo and save it for future use. I mean, I don't know quite what you're saying.
Well, I mean, someone could buy an ounce and then smoke it all,
Right,
right?
right.
Okay.
I don't know if they'd smoke it in one sitting, but yes.
No, yeah, I
Right.
understand that. As a witness.
Through your training and experience on the narcotics squad, was it ambiguous to you that he was dealing drugs?
Ambiguous, I'm sorry.
Was it very clear to
Yes.
you that that was what was going on?
Yes.
Nothing further from the state.
Nothing further.
Anything else?
The only thing I wanted to address is the hearsay objection that the defense made earlier when we approached about the text
Incoming.
messages sent from the other. So I wanted to address that when you're ready. But if there were,
Okay, you can address that now if you want.
thank you, Judge. Judge, it's the state's position that the text messages from the other individuals to the defendant are exceptions to the hearsay rule under 803.3, and it says regardless of whether the declarant is available as a witness, and specifically under 803.3 of the Texas Rules of Evidence, it's the text messages fit into the then existing mental, emotional, or physical condition. Specifically a statement of the declarant's then existing state of mind, such as, I want, or can you get me? In this case, is an exception to hearsay. And also, these text messages fit under what's called an adoptive admission, based on what the defendant is responding to, what these individuals are saying to him. So for those reasons, we submit that they're not hearsay, they're an exception.
And again, Your Honor, just to re-urge the objections that are made, we object that all the text messages are not relevant, Your Honor, to the two special issues that are going before the issue. If they are relevant, its probative value is outweighed by its unfair prejudice or confusion of the issues. We object that they deny, with regards to the responses to the texts, we would say that they violate the hearsay rule, because one of the foundations of the hearsay exceptions, Your Honor, is that we allow hearsay to come into evidence because it has an indicia of reliability. And we submit to the court that in this instance, even with regards to the state's position that under 8033, that they come in, it's unknown declarants, Your Honor. And so that in itself undercuts the indicia of reliability that is required for hearsay admission. And also, Your Honor, denies our client the right of confrontation under the Sixth Amendment as applied to the states to the 14th in Article 1, Section 10, I believe.
Just throw it in, baseline.
In addition, Your Honor, as the detective stated, we don't know, for example, just on the known and unknowns, Your Honor, we don't know if this is one individual with 36 phones or 36 individuals with one phone. In addition, by his own admission, we're dealing with drug users, and how reliable would drug users be in sending these text messages, Your Honor? And so, for those reasons, we're objecting to the admissibility of the entire exhibit, and in particular to the text messaging back to this phone, and only because the court mentioned earlier that you could give an instruction that they're being admitted only for contextual purposes, and I know we do that with, for example, interrogations. But in that instance, Your Honor, again, we know the identity of the declarant. We can cross-examine that declarant and say, well, in this instance, Detective Duke. Okay, Detective Duke, why did you tell him this? And so we can attack the context that this instruction would give. In this instance, we don't. We don't. And that's a problem for us, that we cannot attack the declarants in this text back to Mr. McKane. And as such, it violates our right of confrontation.
Your Honor, the relevance is that the evidence is going to show overwhelmingly beyond any doubt he's a drug dealer. That's the relevance. We're not trying to show the other people are involved in order to try to prosecute them. His character and background are directly relevant per the special issues, despite what Mr. Pettis said. The other thing is, it rebuts what he told Detective Duke, and what we will show through other evidence. He has been telling people, I'm a hard-working man. I work all my life for the city of San Antonio, and that's all I do. I want to take care of my child. I'm a hard-working man. This is going to show, along with other evidence, that the hard work he did was selling drugs. That's how he made his money. And so it's directly relevant. The other issue, and Ms. Strouch pointed out why it's admissible under other hearsay exceptions, but the other thing is, under civil law, this is an offer to buy and sell. This has legal significance. In contractual law, an offer to sell something, an offer to buy something, those words have legal significance. So once again, these aren't offered for the truth of the matter asserted. It's offered to show that he's a drug dealer, and when he says that it's not reliable, the phone numbers of those people are there. You can see who the phone numbers are. If we wanted to, we could track down who those people are. But it's not relevant. We're not trying to show that they were violating the law by buying. We're trying to show that he's a drug dealer, and that goes directly to his character and background, and to rebut the image he's been trying to put forth before this jury.
Well, Your Honor, on that issue, Mr. McKane hasn't testified. He hasn't told anybody, hey, I'm a saint. They cannot open their door. And so it denies our client's right to remain silent on that ground. And then with regards to that they're not offering it for the truth of the matter asserted, they're not offering it to show that he's a vacuum cleaner salesman. They're offering it for the truth of the matter asserted in the text, that they're drug dealing. So how he can come up with that argument, I don't understand.
We're not offering it to show that, oh, I'll sell you 1 ounce for $20. We're not offering it to prove that he's offering to sell it for $20. We're offering it to show he's a drug dealer. They opened the door. The door was open when he was convicted of capital murder. So, you know, that is, and I'm not talking about, we're not commenting on his right to remain silent. What we're talking about is throughout his confession and the things he said in the garage, we're offering it to rebut that, and there's going to be other things that we're going to be offering into evidence, statements he's made, as the court's seen through his video visits and through his phone calls, that will also go to that. So it's not a comment on his right to remain silent. It's a comment, even up to this point, as to what the jury has already heard, strictly through what he's told Detective Duke and what he said in the parking garage.
All right, so I'll consider the defense 404 objections and the 403 analysis. I'll overrule the defense 404 objections and the other objections. I'll conduct a 403 balance. I'll overrule the defense 403. And I've had an instruction prepared. I'm going to read it to you now. And this is what I intend to read to the jury. I've been working on this while we've been doing this. You are instructed that the text messages received by the defendant, if any, and if received on his phone, if it was his phone, are not being offered for the truth of the matter asserted in the text messages, and they are not admitted for their truth. What that means is that the text messages are admitted for the purpose of the context of the conversations in the text messages and for no other purpose. You are also instructed that to the extent that evidence regarding the defendant having committed an act of misconduct or offense, if any, other than the offense alleged against him in the indictment in this case, such evidence cannot be considered for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such act of misconduct or offense, if any, and even then you may only consider the same in assisting you, if it does, in determining the context of what was said by the defendant, if it was, and for no other purpose. All right, anything else?
No, Your Honor.
No, Your Honor, just the objections we made.
Okay, and the objections will be running objections throughout the testimony.
Thank you, Judge.
You're welcome. All right, we've got an hour and 20 minutes. Let's go ahead and take a lunch.
Can we get the heater turned on, Judge?
I guess.
Cold?
It's cold.
Can you hold me? I guess if you'll
may be seated.
All right, welcome back, members of the jury. Hope you had a pleasant lunch. We're going to go through till about 5:30 today, so if you need a break, please let me know. I do anticipate giving you one break during this afternoon session. All right, State, you may proceed.
Welcome back, Sergeant Williamson. I believe before lunch, you were testifying that not only had you been on the narcotics unit for years, but that you had participated in thousands of drug-related arrests.
Yes.
What kind of training specific to narcotics have you received?
Well, to start off in the police academy, I mean, that's the first where the first training comes in, and just the subsequent training, in services and in-unit training in narcotics, from other experts in the field, different schools we've gone to, things like that.
And when we speak about narcotics, are we specifically talking about hard drugs like heroin or cocaine, things of that nature, or does that also include marijuana?
It also includes marijuana.
And can you tell us from your experience in training as a narcotics detective, what type of position has marijuana taken in the overall drug universe?
It's coming to the forefront of the money-making part of the narcotics business. I mean, there's a lot of money being made on it. It seems like more and more people are using it. Again, the legalization in other states you got more higher grade products out there, higher grade marijuana products, which cost more. There's more money being made, so that's causing other problems.
And so when you say it causes other problems, in your experience, what kind of problems are you seeing specifically in regards to marijuana?
I'm going to object to relevance, Your Honor. It is relevant, it's probably the value. It's outweighed its confusion of the issues and unfair prejudice. Unless he can tie it. That's it.
We intend to go forward tying it specifically to marijuana, the defendant's.
So what I'll do is I'll sustain the objection, and I'll let you lead a little bit to get there. That way it's not so open-ended.
Okay. When you go out on the streets every day, or from your office, when y'all are doing drug busts and what have you here in San Antonio, what type of drug is most commonly at the center of those drug busts?
For the most part, marijuana.
In regards to this case against Otis McKane, were you asked to review a series of text messages from the defendant's phone?
Yes.
To and from the defendant's phone?
Right.
And were you able to review all those prior to testifying?
Yes.
May I approach, Your Honor?
Yes.
I'm showing you what's been marked as State's Exhibit 377. Do you recognize these?
Yes, I do.
And how do you recognize them?
They're the text messages that I reviewed.
And they were from this defendant, Otis McKane, to and from other numbers?
Right.
Okay. And you reviewed them in their entirety?
Yes, ma'am.
And this comes from the full extraction of the defendant's cell phone?
That's what I understand, yes.
Okay. And did you find evidence of drug dealing within these text messages?
Every number that I saw text messages from, to and from, there was narcotics being mentioned, talked about.
Okay. At this time, State would offer State's Exhibit 377 into evidence.
Subject to our prior.
All right. So those are admitted.
We have the prior.
All right. Okay.
And what I'm going to do as it relates, I'm going to take this off so you can hear me appropriately. What I'm going to do is it relates to the exhibit that was just submitted. Members of the jury, I'm going to read to you an instruction. I'm going to include this in the charge of the court, but it's important that you hear this now. You are instructed that text messages of any received by the defendant on this phone, if they were received and if they were his phone, are not being offered for the truth of the matter asserted in those text messages, and they are not being admitted for their truth. What that means is that these text messages are admitted into evidence for the purpose of placing any statement made by the defendant in the text messages, if any, into context, and for no other purpose. You are also instructed that to the extent that there is evidence that the defendant may have committed or may have been involved in an act of misconduct or offense, if any, other than the offense for which you have just convicted him, such evidence, if any, cannot be considered by you for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such act of misconduct or offense, if any. In the event you have a reasonable doubt as to whether any other such act of misconduct was committed, or as to whether the defendant was involved in such other act of misconduct, then you will wholly disregard the evidence which may relate to any such matter and not consider it for any purpose. All right, State.
Roughly how many different strings of text did you review? How many different numbers?
I believe there's 35, 36, I have the exact number, but 35-ish.
Did they appear from reviewing them that they were to different individuals?
Yeah, I would say so, yes.
And you can say that just from the context of the text and what was said within them?
Yeah, I mean, for the most part, the text reads slightly different in each one. You know, just if I had a conversation with you, it would sound different. If you had a conversation with somebody else, it's kind of the same thing with text. It reads a little bit different. So it seems like they are.
And you previously testified just a moment ago that within all 36 text strings, you saw evidence of drug dealing or buying, what have you.
Yes, ma'am.
I would like to go through a sampling of them, not to go through all 36 different numbers, but if we could put them on the projector and we can talk about, you can see on that screen there.
Okay.
And on this, the green is the defendant bubble and the blue is whomever's texting him. Is that right?
Yes.
Can you even read that?
It's a little fuzzy, but I can read it. Everybody else can.
And as you can see at the top, it's the Cellbrite report that Justin Knox presented to the jurors earlier today from the full extraction. And so as we go through here, I'm going to flip pages, but I want you to point out to the jury what indicates to you that drug dealing or drug activity was going on. So is there anything on this front page of this first text string from State's Exhibit 377?
Now, the first thing catching my eyes is I need 7. And that could be 7 ounces, 7 grams, you know, but it's an amount. And it catches my eye because a lot of times they talk kind of short, and that I don't want to say, hey, I want 7 kilos, you know. So usually the person they're talking to kind of knows what they're looking for, so they just keep it short. The shorter the better a lot of times. So it kind of catches my eye right there.
Okay. And then proceeding on. And then on here, I think it was testified to earlier that the X means that's a deleted message on there, but they can still pull it from the extraction. Is that correct?
I believe so, yes.
Yeah. Okay. So is there anything on this next page?
Nothing really sticks out as far as drugs on that one. Not without putting it together with everything else.
I think it might be easier, I mean, the jury can see what this is for you just to read off the
That's
pertinent portions instead of squinting.
Yeah, that's fine.
And the jury's squinting as well to see it.
if you could just flip through, and the jury will have all of the text messages with them. So if you would just read the important parts that have to do with narcotics dealing.
Okay, he's saying, yeah, that was crazy. Some was stepped on. I'm reading to you how it's reading. That may not be perfect English, but yeah, that was some crazy. Some was stepped on. How much? Zip.
And is that a red bubble, I mean, a green bubble or a blue bubble?
That's a green bubble.
So that would be from Otis's gun.
Right.
And so what does stepped on mean when you read that?
Stepped on is a common terminology for cutting something. And so let's just say, for example, cocaine. If I get it pure, I'm going to cut it with something, mix something else with it, which kind of dilutes it, but also increases the amount I have, so I make more money. So there's two reasons there. So that's what stepped on means, to introduce something else into it, to dilute it, or make it more quantity out of it.
All right, so the defendant is texting someone that it was crazy stuff, he stepped on it.
Yeah, and he's asking how much for a zip. A zip is short for an ounce. There's a different term for ounce, but a zip is a term for ounce.
All right. And what else in that text string stands out to you?
Okay, the blue box 11, but I just did one up. He got the flame again, no BS. Then he replies, "Can you get a 7 for me? I got 250 right now," which tell me he's asking for 7, but 7 of could be grams, could be ounces. And he says, "I got 250 right now," which just does tell me I got $250 for the 7.
And is that from the defendant's phone saying he has 250?
Yes.
Or someone telling him?
From the green box to the defendant.
So in this situation, he's seeking to purchase drugs?
Yes.
Okay.
And then, let's see, about to grab from hiking a minute. I got you. Later on, got you the whole 275 if you're ready for me. Goes on. Goes back and forth about calling somebody and I'm waiting and things like that. And the other person is in the blue box saying, "I got bars." Bars is short for handlebars or Xanax pills. So they're kind of long, skinny pills. So they call them handlebars or bars for short. Okay, so he's asking in the green box.
When you say he, do you mean Otis?
Oh, Otis. Yeah, I'll just say Otis from now on. I'm sorry. So Otis is saying, "I've been looking for you. I'm sorry. It's hard to read this when it's not in proper English. I've been looking for you. I've been working." The other person's replying, "I've been working, but what's good, boy?" And Otis says, "Chillin', trying to find some good dro." Dro is short for hydroponic marijuana, the higher grade products. And there's different levels of marijuana. The lower grade, the higher grade, which is the hydro or the dro. And that's what he's mentioning here. And the other person's saying, "Yeah, I ain't got any right now." And he says, "Hit me when you get good. Okay, when you get some, let me know."
Can you tell us what is hydro going for on the street these days? What does it sell for?
So per a pound, you're looking probably $2,500, $2,500, and if I buy that and I sell it in smaller quantities, I'm gonna make a little more on it. So on the low end, maybe $1,500 to $2,000. On the high end, $4,500. So right in the middle, around 3.
Okay.
That's about it for that one.
All right.
We just go to the next one.
Yes, if you would, please.
Okay, this is the other person starting it out. You got a dime, and a dime is a common street term for $10 worth of coke, heroin, weed, whatever, and so that's a common term used for drugs. So he says, "You got a dime?" Otis says, "Yeah, I'm at the house." The other person says, "All right, hang on." And so that's the bulk of that one. But that's if somebody's asking for a dime, he's saying, "Yeah, come on, get it."
All right.
Next one. There's another one that says, "You got a dime?" "Yeah." And the other person says, "Can my uncle come get it?" Otis says, "Yeah." He's going to text you from his phone. It says PHO. And then another message is he's going to text you from his phone. And Otis says, "Okay." Again, somebody else asking for a dime.
Okay. And they want to come by and pick it up.
Right. I want to come by and pick it up. Okay, and there's a person looking for him, trying to get a hold of him, like, "Are you home? Yo, yo." And then he finally replies, "I'm out, text when good." "I'm out, text when good." Again, he tells me that's short for, I don't have anything right now, I'll text you when I have something to sell you.
And do all of these text bubbles that you're reading from have red X's next to them?
Yes. Yes, I believe they all do. Okay, so it goes on a little bit. So Otis is initiating this one. "I'm good if you still want it." And the person replies, "What up?" And Otis replies, "I'm not home yet, text when close." "Let me know to move," is what the person is replying. And Otis says, "Be home in 30 minutes. You can head that way." The person says, "Okay." The other person says, "He didn't move, park." And I'm assuming they're talking about a police that wherever they're going to meet, they saw somebody, because the next message from Otis is saying, "You good? That was the park police." And then later says, "And take your time with that stuff. It's powerful."
And that's Otis saying that to someone?
That's Otis saying that to the person that he's speaking to another end of the text chain. And the other person says, "Looks like it." And so looks like a different time, and that person is texting back, "You still got powerful?" So you can kind of see what I previously said. You still got that powerful stuff. And Otis says, "Yes." "Get back to you a little later," is what the other person says, and then Otis tells him, "I'll get off at 10. Later on, Otis says, "I'm at home if you still want." "Yeah, give me 40 minutes, homie." That's what the other person is replying. "I knock on your door." The other person is texting again. Otis says, "You here?" The other person at McD, which is McDonald's. So you're just hearing talk about meeting different places. "You here?" "Yeah, I'm here." McDonald's, that kind of thing.
Does Otis McKane also deliver what people buy? Is there evidence of that?
Yes. Yes, and I believe that this one, or if not, another one here I got here, have that. He's going to say, "I'm home if you want it." Some other. Okay, here's another one. The person saying, "I'm leaving WW right now." And he replies, "What do you got?" Otis replies, "What you got?" The other person says 20, which another $20 for $20 worth of dope. Okay, meet me on 35. Meet me on the Broncos in 35 is what Otis says to him. "I'm in a car, A-H car, a car." And the other person replies, K, at light. So he's updating. "Okay, I'm almost there. I'm at the light." Otis says, I'm at the Texaco. Then the other person saying, not that good. And this is, let's see, later on the day, the other person saying, not that good, exclamation point. And Otis is saying, yeah, but I got a lot, serve more next time. So it's lower quality stuff. It's, I'll give it next time. I'll give you more next time because it's not that good. And so the other person's text, we cool. Can you get good soft and high demand here? Soft is a term for powder cocaine. There's two forms of cocaine. There's what they call soft, as the powder, and hard, which is the crack cocaine. It's just another name for it. So the soft is talking about powder cocaine.
Can you explain to us how does soft powder cocaine become crack? How do you make that happen?
Objection, Your Honor, unless there's some specific evidence of crack, then it's not relevant. If it is relevant, the proponent value is outweighed by its unfair prejudice or confusion of the issue.
Well, grant the 404 if you want to lead up to that to show how it is a relevant issue.
Is there a text message somewhere in there that leads you to believe that crack was being talked about?
Yes.
Is it in this one, if you know?
I don't remember if it's in this one or one of the other ones, but it is in here somewhere.
Okay. Will you let us know when you come across it?
Yes. Let's see. Okay, the other person saying, any better stuff? Like, you got any better stuff? He says, I know, give you a lot. So he's basically saying again, yeah, it's not great. I'll give you more. And again, don't understand the quality. This other person saying, don't understand the quality. Not good. I have Oni. And Otis saying, it's bad, so I'll give you more. Again, you see that he's trying to hook him up and give him more because it's not the best quality. Okay. The other person saying, what do you got? And he says, the other person says, that was cool. That was cool. Let me know new batch. Yeah, not perfect English, but he's letting me know, hey, let me know when you get a new batch. And Otis replies back, I got a lot of it. You just got to cook it down.
And what does that indicate to you when you hear the terminology, you just have to cook it down?
That tells me is when you cook something, and when they're talking about soft before, and they're talking the next thing you know, they're talking about cooking. That tells me they're cooking the crack, or you have to cook it down. Where was I? Okay. The other person says, rocket science, I got you. What else you hook up to? Xanax, ecstasy, money to be made. That's what the other person replied, or is asking. Let's see. And Otis replies, nuss, bud, and work. I believe he's saying, I just got bud with marijuana.
Can you tell us roughly what dates these text conversations span?
Yeah, this particular text chain that I'm started with was started in April 25th, 2016, and I'm now to May 21st, 2016.
When you went through all these text messages, what are the latest texts that showed evidence of drug dealing on Otis McKane's phone?
It was, I believe I said the day before, it was in November. I forget the exact date, but it was in November 2016. Alright, so we're here. May 24th again. The other guys Other person is asking, anything new? Otis responds, no, but I gave you a good deal. I'll give you 80 for 40.
And what does 80 indicate?
I'll give you $80 worth of something for $40, or 80 grams of something, or 80 grams for 40. And that person says, same old, and it says, yeah, good. Otis says, yeah, a good deal. Over to May 26, 2016. The other person says, found some quality on Austin Highway. And then Otis saying, I got some good stuff. It's different. And then again, I got some good. And that's the end of that chain. All right, so this next one, the person's asking or saying, got flame on deck. Sub G, he's trying to get his attention. And that tells me one of two things. I've heard marijuana called flame, and also cocaine or crack cocaine. So I'll move on. So Otis says, you got another 8. And
what does an 8 indicate to you?
An 8 indicates to me an 8 ball. That's short for 8 ball, or an 1/8 of an ounce. And that's, if you break that down, that's approximately 3.5 grams. So it's not all that much. If you're talking about marijuana, that's not all that much. If you're talking about cocaine or heroin, one of those, then it's more an 8 ball is more commonly used for, again, cocaine and heroin, because that they're a lot. Those smaller amounts go a lot further, if you get what I'm saying. So that term is more commonly used for cocaine, heroin, things like that, methamphetamine. Okay, so Otis says, you got another 8? The person says, yep. He asks, can you bring another one? And the other person says, on my way there, G. I'm up the street. It's hot in your hood. And that's terminology, not because it's hot outside, but the police are around. It's hot over here. That's how they talk a lot of times, to say the police are around. It's hot over there. Let's do it somewhere else.
All right.
Again, Otis is asking, can I get it at 8? And the other person says, yeah, where you at? Otis says, Walgreens on Claiborne's hours or more. On my way, be there around. On my way there, I'm around here, fam. Again, Otis is asking, you up? The person responds 24/7. Otis says, can I get 8? At home, he says. Can you? And the other person's asking again, can you meet? It's hot in the hood. And he said, there's a lot of police over there. Let's do it somewhere else. Do the deal somewhere else. And Otis says, the car wash by Valero on Calabria. The other person says, bet. Like you bet.
So in that text message string, does that indicate to you more that they're talking about cocaine or marijuana?
Based on what I'm reading so far, I would say cocaine. Just because like I mentioned before, the term 8 ball, and rarely ever hear that used when you're talking about marijuana. It's more cocaine and things like that. Okay, so that whole text change started April 27, 2016. Now I'm on May 1st, 2016. So the other person sends a text, says, flame, huh? And Otis replies, yep, thank you, smell though, be Dan. And the other person later on, sub G. And then Otis replies, got white cookable, pay good for it. So he's asking for white cookable,
What does that mean?
looking for cocaine, white cookable. That is, you get the cocaine powder and you mix some other stuff with it and you cook it into crack cocaine. So that's white cookable, and that's what we were talking about before. So Otis again got white cookable, paid good for it, FUD. And again he says I cook.
Who says that? Otis says I cook.
Otis says I cook. That's telling me he's looking for crack to cook up. He cooks. He's telling the guy I cook crack. I need some cocaine to cook up. The person here, again, it goes kind of back and forth. May 2nd. The other person texts, yup, sup, whatever that means. Otis replies, 8. Can you meet me at Mickey D? So he's saying I need an 8 ball. The other person replies, in 30 minutes, G, by medical. So I'll be there in 30 minutes and we're by medical. Otis says, okay, hit me up. Okay, the other person replies. Again, they're talking about meeting up and close, that kind of thing. Now we're to May 5th, 2016. Another person says, sup, G got perp. Perp is a short for high grade strain of marijuana. And so that was May 5th. Later on, he responds, Otis responds, still got perp? The other person says, yep. Otis responds, can you bring it 8? Back and forth. Home, yeah, I'm home. So another one. We're on June 3rd. May 28th. Need any G? So he's asking Otis, need anything? I don't see a response. He's saying here. Says need any, and then he's saying here. A couple hours later, 3 or 4 hours later. So I don't know why he would deliver something unless there was a call him or something. So we're to June 3rd, 2016. The other person says, "Can you get Pix G? You got some exotic." Exotic is another high grade marijuana. Otis says, "Okay." Otis says, "My boy gonna call you. He is 6'3" Mexican." And the other person says, "What's he need?" So he's trying to hook somebody else up with this guy to get drugs.
So in that text exchange, he's facilitating some other person getting drugs from someone other than him.
Right, he's acting as the middleman, basically. What I mean by that is, instead of, say, if she was selling drugs and I went up to buy it, I'm buying it. But if I don't want to get involved, then, this other person rather than buy it from me and listen to this. So I'm facilitating the deal between the two, but I'm not touching it. I'm the middleman. In other words, I'm just setting the deal up. What do you need? Otis replies 8. The other person, is he legit? And what's his name? G, because I just don't deal with new people. I just did with you crazy, with you because sleepy, whatever that means. And Otis replies, he's good. He good. So we're to June 11th, 2016. The other person got good Dro G nugs. Dro, again, hydro, the nuggets, the bud of the plant, the marijuana, call them nuggets. Again, Otis says got 8. November 14, 2016. This person is saying, what do you need? And Otis replies, I got 60. But I got to go to the ATM real quick. What are you looking to get, G? The other person asks. And Otis says, can you hook me up with a 60?
What's a 60?
Just $60 worth of the product he's trying to buy. And, yeah, that's about that one.
So, do you have more samples up there, or?
A couple more. Let me go through those.
Sure.
All right. This next one starts on April 26, 2016. And this person's asking, can you drop? I mean, can you make a drop? Can you bring me something? That's they call it making drops. We're rolling around the city, dropping off to different places. So that's where the term drop comes from. Can you drop? Question mark. Otis says dub, right? I'm at the stove.
What is dub?
Dub is a term for $20 worth of whatever drug you're looking for. So where are you at? I'm about to bounce, Otis is asking. So it sounds like if somebody's not there, they start to get worried because they think they're being set up. So he's asking, where are you at? I'm about to bounce. I'm about to leave. Person replies, 1313 Northwest 19th Street is my address. I'm walking to the store. M, whatever that is, whatever M is. He's asking what you got on. He's trying to identify the person by what they're wearing to make sure he's not getting set up. That's common. Black hat, black shirt. The other person replies. Another person then says, "Got a dime?" That's the next day. I'm sorry, the next day that person says, "Got a dime?" Again, he's asking for a dime, $10 worth of drug. And Otis replies, "Yeah, but I work." A couple days later, got bud? The other person asks, "Got bud?" I need a dub. And Otis replies, "Yeah." Another person, "Can you drop off or want to meet me at the store?" RQ, whatever RQ is. Otis says, "I'm not leaving my house tonight. You have to come here." So, July 25th, 2016. It says, the other person says, it's the uncle. I just need a dime. And he says, "Let me know something." Just a few minutes later. And Otis replies, I'm at home. The other person replies, "Is it ISSLKT? Is it cool to go by?" On my way, is what they say. And then they say, "I'm outside. I'm here. I'm at the back door. I'm here waiting on you, bro." Got the next day, "Got bud?" Otis replies, "Yeah." "You home?" So I go by, the other person says. And then they say, "I need 20. I need a 20. Now we're in July, all the way to July 31st. "Can I get a dime?" That person's asking. Otis, "Yeah." The other person, "On my way." The other person, "Can I get a dime?" Otis replies, "Yeah."
So as you've gone through, and that was just a sampling, there are more.
Yes.
You found evidence of talking about cocaine, crack cocaine, Xanax, hydroponic marijuana, and anything. What else did you find? Or was that it? Let's sum it up.
I think somebody mentioned it. It was asking about ecstasy also.
Oh, excellent. And all of these span
I think you told us, from April roughly of 2016 all the way through November of 2016.
Yes.
So you were talking earlier, I think probably before lunch, about drug use, marijuana use in particular, leads to other problems and issues within the city. What kind of things have you seen in your position as a sergeant in narcotics?
We're gonna check, Your Honor, it's not relevant, and if it is relevant, it's probative value, it's outweighed by its unfair prejudice, confusion of the issues. It's not relevant because it hasn't been tied to this defendant, Your Honor.
As an expert on narcotics, trafficking, and dealing within San Antonio, I think it's probative for him to speak about it, as well as he just spent the past half hour discussing all of the things tied to drug dealing we found on the defendant's phone.
Yes, Your Honor, what I'm suggesting that this officer is gonna talk about kilos of cocaine and kilos of black tar due to the community, as opposed to a low-level nickel and diming, dime and duck. It doesn't equal, Your Honor, and therefore its relevant value is outweighed by its unfair prejudice, Your Honor.
Awesome. You gonna say something?
Oh, go ahead.
All right, I'll sustain the 403.
I'll pass it, Ms. Judge.
May I, Your Honor?
Yes.
Sergeant Williams, good afternoon, sir.
Got the win this time. Thank you.
I'm sorry?
I said you got that win. Thank you.
Okay. Yeah, I heard from earlier, right? Okay, so we know you have experience in narcotics, but I want to differentiate between narcotics includes like all the penalty group things and the like, you know, the Schedule 2 penalty group, like I just stated to the court, cocaine, heroin, black tar, methamphetamine, and all those items, correct?
It includes marijuana, heroin, cocaine, all those.
Yeah, but
We'll talk about
under the
narcotics.
Health and Safety Code, the penalty group narcotics in one section, and then marijuana has its own section, correct?
Right.
Okay. You testified that a pound of throw goes for about $2,500, maybe $3,000.
Right.
I didn't see anything in this phone talking about purchasing a pound of throw, did you?
Didn't see a pound though.
Okay. And I believe you said that in all this months, maybe there were 34, 36 numbers associated with this. Is that accurate, roughly?
Yeah, 35, 36, something.
Okay. And, you know, we talked earlier, and you said that in reality, most of the transactions here, for lack of a better expression, are for marijuana, right?
The majority, yes.
Yes, sir. Now, you saw, and you testified earlier, that when you see the phrase an eighth,
Sorry, eight?
an eighth,
Okay.
that it can refer to an 8 ball. Is that accurate?
Right.
And we can apply the terminology specifically 8 ball to cocaine, and we can apply it, I guess, to heroin too, correct?
Any drug. It could be any drug. It's just more commonly used with the harder drugs.
Correct. But generally on the streets, nobody says, hey, you got an 8 ball of marijuana? Nobody says you got an 8 ball of marijuana, right?
That's not common, right?
That's not common.
Right.
And so when you testified before this jury that when you first saw the phrase, hey, you got an eighth, that you said it can refer to heroin, cocaine, or marijuana, right?
It could refer to anything, like I said.
Correct.
Just more
Name.
commonly the harder drugs.
But did you ever see the phrase 8 ball in any of this text?
8 ball? No,
Yes,
it's
sir.
not 8 ball.
Okay. and you equated 8 ball to an eighth in your testimony, correct?
8 is short, commonly used for, is short terminology for 8 ball.
Okay, but what the point I'm
Or
making
or
is,
an eighth of an ounce.
Okay.
Which is the same thing.
and then, now what would an 8 ball of black tar heroin go for on the streets in San Antonio?
$150.
You said 150?
Yeah, 150.
Okay,
Approximately.
an 8 ball of black tar heroin.
Approximately.
Okay.
$150, $200.
And you see that on this phone, I mean, there's like, can we meet over here, can we meet over here, for a dime? You see that for $10. You saw that? For a dub, $20, right? Yes?
Right.
Okay. And there were numerous times you testified with regards to this 8. And you said that perp is marijuana, correct?
Yes.
And you said that, according to the text, Otis, if we're thinking that it's Otis here, you said, can you bring an eighth, right?
That's what it sounded like, yes.
And can you bring an eighth was referring to marijuana, which equals perp, right?
I'm sorry.
Well, in this exchange, because I'm trying to clarify this eighth thing, you can see where the individual that you're referring to as Otis McKane, when they say you got perp, they're referring to marijuana, right?
Right.
Okay. And in this instance, you testified that it was replied by Otis McKane, can you bring an eighth? Right? You
Right.
testified.
Well, it could be 8 grams, it could be 8 ounces.
Well,
You know, it just depends on the context you're putting it in.
okay, but what's more likely for you to get on marijuana when you're talking about an eighth for $10, let's say?
For
Is
$10.
it more likely that you're going to get, what can you get, 10 grams or 10 ounces? Or you see what I'm saying?
So I don't understand how much you gonna get for $10? Is that what you're asking?
Well, you said it can be, that an eighth can be, what, 80 ounces? Or what did you say?
As I said, it's commonly referred to as it commonly is referencing an 8 ball. Now, in a different chain, an 8 maybe, if you're talking about marijuana, maybe 8 grams. It may be 8 ounces. Yeah, and maybe 8 pounds. I don't know. It depends on the chain.
Okay, but if we go
Context.
from pounds to ounces to grams of marijuana, between those, what could I get for $10 of marijuana?
What kind of marijuana you want?
Well, let's say grow.
Hydro for
Yeah.
$10? Not much.
Not much, right?
Not much at all. Nope.
For sure you're not going to get anything in that pound, right?
For $10, no.
Okay. So you can get a couple of grams maybe for $10 of marijuana, even grow the good stuff, right?
A couple of grams for $10, Dro? No, probably
Not even Dro.
It's probably the lower grade stuff.
Swag, right?
Yeah, that's one term for it, yes.
Okay. So in this, generally speaking here, you're talking the dimes and the dubs, which are $10 and $20. Would you agree with me that those are low-level sales?
Yes, sir.
Okay. There was another occasion where there's an exchange, and the phrase "you got exotic," you said that's another phrase for high-level marijuana, right?
Right.
And you testified that the response by Otis McKane, you got an eighth. Again, an eighth. The phrase that he uses, an eighth, he was talking about exotic marijuana, right? At least that's what I heard you say.
Yeah, I just don't know. It may have been the next day when he was asking for something else. I don't know.
Well, I
really
don't know. You were the one that was reading. You said that.
I can go back and find it if you want me to.
I'm sorry?
I can go back and try to find it if you want me to.
Yeah, I mean, look for
Are
it.
you looking at a number? If I could help me narrow it down.
You know what? I didn't put the date down.
Okay.
But, I'm just saying, the testimony and the jury will remember what your testimony was. But could you, do you recall that you testified that when, and if I'm wrong, believe me, they'll correct me, that when he was asking or he was asked about exotic, your testimony so far is that exotic refers to marijuana.
Right.
Okay. And we know that at some point, McKane, in referring to perp, which again is marijuana, he used the phrase, "Can you bring an eighth?" We agree to that.
Sound if
Okay.
I remember right, yes.
Okay. And so, and again, I thought that when you mentioned that he was talking about exotic, again, marijuana, he referred to it as, can you get an eighth? Again, an eighth, in reference to marijuana. Do you remember that? And you don't, that's okay.
It all bleeds together. Again,
Okay.
there's a lot of eights and a lot of stuff in where it's broken up and to what date. If it was the next day or if it's talking about the same thing, I haven't looked back. To be
Well,
honest.
I thought you were going in sequence, but.
It wasn't sequence, but if I'm talking to you right now and you say one thing and then I text you at 3 o'clock in the morning, you got an 8. Well, that's a lot of time difference, even though it may be within 12 hours or whatever. You know what I mean?
Okay.
It may be a different conversation.
And then there was another exchange where there's another phraseology that you brought up, and he says, you got any Dro nuggets? And you said that Dro nuggets, again, refers to marijuana.
Yes, sir.
And maybe you remember or don't, that Otis said it got an eighth. Do you remember that?
I don't remember what he specifically said right after that now. I don't
Okay.
remember.
I mean, but you wouldn't, you agree that in reference to marijuana, Otis referred to an eighth?
There was sometimes, yes.
Yeah. Okay.
He said 8. Now, again, I can tell you in terms of marijuana, that's not that much, so I would assume that would be maybe something different, maybe more.
Well, we know that, generally you would agree with me that, he's nickel and diming basically.
He's selling dimes, yes. He's selling 20s.
Yeah.
He's selling, sometimes more.
And also, apparently, he's not even selling the good stuff because they keep telling him, hey, that wasn't good stuff, you gotta give me more stuff. So not even the good quality stuff.
That was one guy. I can only remember one conversation like that.
Okay. Thank you, Sergeant Williamson. That's the witness.
Just a couple questions. Nickel and dime or otherwise, was this defendant still clearly drug dealing from the evidence on his phone?
Yes.
And was he clearly drug dealing not only marijuana as well as cocaine and crack cocaine?
Yes.
Nothing further on.
In the prior hearing, I asked you, the amounts that we're talking about are basically on marijuana personal use, right? Just generally speaking.
If what he's selling, yes.
Yeah, okay. Thank
Some
you.
of it.
Yes, sir. Thank you. No further questions.
Nothing further from the state, Your Honor.
All right, you're excused. If you want to. Thank you.
Thank you.
All right, State, call your next witness.
May we approach, Your Honor?
Yes. Matter outside your presence.
All right, for jury. You may be seated.
All right, did you have anything else you wanted to?
Well, just what I already put on the record, with regards to what are the number of the descendants?
370, 368, 369, and 370.
No, I mean, those are 3 exhibits I'm missing, so that's probably not.
Okay. All right, so State, did you want to respond with anything?
Yes, sir. Number one, their client, I'd like the court to view these. They're approximately 20 minutes, and there's absolutely no evidence what Mr. Pettis told you that any stop was put to these media interviews. Each station got a 20-minute time limit to interview them. When you watch the interviews, he clearly consents. And that's the only issue. It doesn't matter if Mr. Pettis says, hey, I don't want you to talk to my client. The issue is if the client wants to talk to them, and clearly he did, as you can see from there, that the inquiry stops right there. I mean, these media people didn't force their way in. This man, you can see from the interviews, agreed to, and in later jail visits, you can hear him say, my attorneys told me not to talk to the media anymore. So whether they wanted to talk to the media is beside the point. He agreed to talk to the media. There's a United States Supreme Court case, Judge, it's kind of analogous, the Montejano, I think, versus United States, wherein even if you're represented, and this is for law enforcement, and here we're not even talking about law enforcement, so there's no Sixth Amendment violation because we're talking about, the media. But even if it were law enforcement can go talk to somebody who's represented and say, hey, we'd like to talk to you, even if they know the lawyer doesn't want them to, as long as they read the rights to the person. If the person then says, yeah, I'll talk to you, then everything is okay, and they can talk to them. And in this instance, it wasn't law enforcement, so the Sixth Amendment isn't invoked. And he agreed, I really encourage the court to watch these tapes. He clearly knows what he's doing. He clearly agreed to the interviews. As a matter of fact, he sets down specific ground rules with the media for the interview. And we can show, all 6 or 7 different media people that went in, and at no time do you ever see Mr. Pettis, at no time do you ever see a stop put to any of the interviews. And even if that were the case, he doesn't have the right to do that. It's analogous to their client. If he wants to take the stand to testify, his attorneys can't keep him off the stand. He can talk to whoever he wants. It's not up to his attorney. So this was a voluntary, and because it's not government action, the Sixth Amendment is not involved. And I, encourage the court to take the, and you don't even have to watch the full 20 minutes, Judge. You can just watch the first few minutes of each one, and you can see it was this man's free choice. He was under no compulsion. He was the one that set the ground rules for the interview, and these are admissions of a party opponent.
Well, Your Honor, when Mr. Delgado says that there was no government action, to me, law enforcement is all the state. And it's clear that the police, the DA's office, the jail, they're all the state. And the state let them in to the detention center. And the state prevented me from having an interview with my own client. Okay, now I can't tell you all the specifics of what happened in there for the same reason that I was not allowed to go in there. All I can tell you is by the time I did, there were different cameras there. I can't tell you which ones or who. I just remember that there was a woman in there talking, and then at some point I told the lieutenant to end it, and they ended it. I don't know all the specifics of it, but I can tell you that my attempts to enter and speak to my client were prevented by the state because I had to go through 3 staff members from detention officer to sergeant to, I mean, I couldn't tell you exactly, maybe it's a captain or a supervisor, I had no idea. But it was the 3rd person I spoke to that finally allowed me to go in and speak to Mr. McKane.
Your Honor, he keeps confusing what he wants with what his client wants. It doesn't matter what he wants. His client agreed to this, and you can see that. And, you know, if the court will look at these, then we can supply you with a couple of cases from the Court of Criminal Appeals on point, which talk about media interviews not being government action when somebody like Mr. McKane agrees to talk to the media.
Again, Your Honor, we're
The
just,
sheriff is an intervening party.
well, again, Your Honor, we're just asserting to the court that by the sheriff's office allowing them in, and then the sheriff's office you know, and I don't know about these other cases, but I don't know if there was a lawyer there in those cases trying to, at that moment in time, and I have a 6th Amendment right and an Article 1 section of the Texas Constitution right to see my client. I mean, that's why we can go at 3 in the morning if we want to see our client. And I'm an officer of the court. I'm representing to the court that I made those attempts, and I was prevented. And so, you know, we assert to the court that unless they have a case on point, that even if a lawyer is there attempting to talk to their client, that the media can still do whatever they want, or the jail can do whatever they want, then I guess I'll stand corrected. But in this instance, that's exactly what happened. And so we're objecting under the 6th Amendment, supplied to the states through the 14th Amendment, and they're Article 1, Section 10 or 9, I believe, Your Honor.
Well, Your Honor, we'll supply you with some cases. If they can supply a case that stands for the proposition Mr. Pez is putting forward to the court, I'm ready. I think we're ready to see it and talk about it. But they've known about this issue for a long time. They've had these interviews for a long time, and they don't have any case law to show you. And they have not cited any provision of the code.
All we're doing, Your Honor, is we're making our objection, and I guess you can overrule this or sustain this, Your Honor.
Right, so let me review 368, 69, and 70. I don't have the ability to do it with this.
And if you want to go back to, may I approach?
Yes.
And the, just for 368 and 369.
Are we on the record, Maria?
No, just explain. 368 and 369 are
So I've reviewed the case law that the state has submitted.
If I may, before the court makes a ruling, a further objection, Your Honor,
Yeah.
is that, and we're not too sure what portion this particular DVDs have. We know there's the raw data, let's say from start to finish of the interview of a particular broadcast station. But 38011 talks about something that was broadcast. Now I can tell you from experience that anyone can be interviewed for any period of time, but what is broadcast is a very, very small portion. And so we're also lodging an objection that whatever admissibility the state is trying to get in on this issue, that they would have to establish that that was really broadcast. In other words, that if I was watching TV, I saw it on the broadcast news, if you will. And so we'd object to, if in fact that is the total raw data, which I think the state represented to us that it was, we'd object to any portions that were not broadcast, Your Honor.
Your Honor, 38111 doesn't say that it has to be broadcast. It talks about a recording that purports to be a broadcast. And as the court can probably see from the Ken's recording, that was taken from their website, and if you go to the Ken's website, you can still find that recording that they're being broadcast.
What's the probative value of it?
Your Honor, it shows the attitude. In closing argument, Mr. Pettis told the jury that Mr. McKane had come clean and had expressed his regret for what he had happened. When you watch this video, you'll see that that is not the case at all, and anything that the defendant says is an admission of the party opponent when offered by the state. So this goes to his background and character as the special issue holds. So we think it's very relevant for the jury to put this person in perspective. It is certainly at odds with what his defense was arguing in closing argument to guilt innocence.
Isn't that kind of like attacking the defendant over the shoulders of counsel, Your Honor, which is not permitted?
I don't see how is that at all.
And Your Honor, an attorney's statements or closing are not evidence. That's the first thing we tell the jury. That's not evidence. I understand that we put on some testimony to that effect, then they can do this, but we would assert to the court that these videos are not relevant, and again, if they are relevant, its probative value is outweighed by some sort of prejudice or confusion of the issues, and in particular, on the capital murder case, it doesn't go to any relevant factors with regards to special issue number 1 and special issue number 2.
And it doesn't purport to be a broadcast.
Oh, and of course that, I don't think those were broadcast.
The statute doesn't say they have to be broadcast.
I
And
don't
this is
think it
punishment.
purports to be a broadcast. It's a recording, not a broadcast.
The Ken's one is still being broadcast. You can go to their website, Judge, and see it's still up there. This man's been convicted. The court in the punishment phase can consider anything the court deems relevant to punishment, and this directly is addressed by one of the special issues. The jury's entitled to know that this man who supposedly came clean and is expressing his regret, and let's just say expressing his regret, which has nothing to do with what his lawyer said, it's what they see him saying in the garage, is not the same man 2 weeks later, or for that matter, 4.5 years later. He is still maintaining his innocence even after he was convicted, and we will be offering evidence to that extent too. So this is all evidence of a peace, Your Honor.
And just to make sure, we're still objecting that he was denied the effective assistance of counsel pursuant to the 6th Amendment that's applied to the states through the 14th, and they're in their Article 1, Section 9 of the Texas Constitution.
Okay. You guys have anything else to bring in? Is this it?
I'm not sure what you're asking. Anything else different? Is this it in terms of the videos, Your Honor?
Is this it in terms of evidence?
Oh, no, Your Honor.
Okay.
We have additional evidence.
All right. So who provided this for me?
Mary.
Mary?
Oh, that's mine.
Let's see what else you have. I'm going to reserve the ruling on this one. I kind of want to see where the evidence takes us. And it's based on a 403 analysis. I recognize that it's a relevant issue. I recognize it's admissible per the cases that you've given me, although they're not a death penalty case, right? You haven't provided a death penalty case to me. These are all...
Those cases just deal with the Sixth Amendment right to counsel and Miranda 3822, and how the defendant has to show that the news media were acting on behalf of the police when they took a statement. And no showing has been made. So those stand for that proposition.
All right. And so recognizing that, I'm considering the 403 objection. So let's see where else we go. And then can you do that? Okay. Go ahead and call your next witness.
The state calls Larry Hill.
All right. Let's go ahead and bring him in.
Mary 383. Yes.
Your Honor, may I approach?
Yes.
Regarding the Ken's video, the defendant is asked point blank by the interviewer, knowing everything that's going on, what do you think should happen to you? And his response is, I think I should walk out that front door right now. I think that's extremely relevant testimony for a jury to hear about the mindset and dangerousness of this man. So I would want to make sure that that's in the record.
Yeah, and the court reviewed the Ken's 5 video in its entirety also.
All right, for the jury. You may be seated.
All right, welcome back, members of the jury. State, call your next witness.
State calls Larry Hill.
Oh, so you can have a seat. I'm going to swear you in, okay? Do you solemnly swear or affirm that the testimony you give in this trial will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you approach the microphone. Make sure everybody can hear you. Now, since you're speaking, sir, yes, if you can outside the jury can observe. Okay? Yes. You have a hearing? Okay. So if there's anything that you cannot hear, please let me know. If you don't say anything, then the lady in front of you, the lady keeping a record, it's going to indicate that you can hear unless you say something, okay? All right, can you introduce yourself to the members of the jury and spell your name for the court?
My name is Larry Hill.
If you could spell your name for the lady, please. Is your name spelled Larry and then Hill Hill?
Yes, it is.
Okay. State.
Thank you. Mr. Hill, I don't mean to embarrass you, but you have an issue with your hearing, is that correct, sir?
Yes.
Okay, can you hear me okay?
Yes, yes I can.
I think I've got a pretty loud voice, but can you tell the members of the jury, do you live here in San Antonio?
Yes, I live in San Antonio now.
Okay. Where are you from originally, Mr. Hill?
Originally from Detroit, Michigan.
Okay. And just to let the jury know a little bit about yourself, when you left Detroit, did you join the service?
Oh yes, I went joined the Army.
Okay.
13 months in Vietnam.
All right. Well, so thank you for your service. You served in Vietnam, and then once you left the Army, did somehow you get down to Texas?
Yes, I had a good friend of mine whose mother lived in Kingsville, Texas. She's about 90 years old, and they needed somebody to help them drive down there to relocate. And it was a good opportunity for me to go down to get out of the city, because I'm more country, I like more country.
Okay.
So we got together, went down, hit the highway and made it to Kingsville.
All right. And did you work and live in Kingsville for a while?
Yes, I stayed in Kingsville, Texas for a little while. I worked for a pool oil well company. They work out at El Campo, Texas, yes.
Okay. And then at some point, did you leave Kingsville?
Well, about a year after, because the weather started getting bad out in the oil field, more like monsoon. I left that and came up to San Antonio and worked for the Kerrville Bus Company. And stayed there for about a year or two and finally got a chance to work for San Antonio Water System. Worked with them for 28 years. I retired about 8 years now.
All right. And what did you do for San Antonio Water Systems?
Well, wastewater, what I call it, water recycling technician too.
Now, Mr. Hill, are you married?
Yes, I am.
And what is your wife's name?
Royce.
I'm sorry, what is it?
Royce.
Royce, okay. And how many years have y'all been married approximately?
35, 36 years.
Okay, and do y'all have any children?
Oh, yes.
And who are your children that you and your wife have? Do you have a daughter, sir?
Yes, I have a daughter.
Yeah, and what is your daughter's name?
Sahara.
Okay. Sahara? All right. And let me go back to your wife for a second. Did your wife ever work as a dispatcher?
Yeah, Bear County Sheriff 911 dispatcher.
Okay. So she worked for the Bexar County Sheriff's Department, correct, as a dispatcher?
Yes.
Okay. She never worked, or did she work for the San Antonio Police Department or the Bexar County Sheriff's?
Just the Bear County Sheriff Department.
Okay. Now, your daughter, Sahara, and without telling me your address, what part of town did y'all live in back in, like, I don't know, around 2012, that time period?
Well, east of San Antonio.
Okay, and your home, is it in the city limits or is it in the county?
County.
And would you describe, kind of, just for giving an idea to the jury, is it kind of like out in the country?
Oh, so say again, please.
Is it kind of like out in the country, your home?
Oh, yes, out in the country, it's space.
Okay. Now, at some point around 2012 or around that time period, did your daughter begin dating someone?
Yes.
I'm sorry, I think it would have been, I'm using 2012, I think it's more appropriate, 2009. At some point, did your daughter bring home a person by the name of Otis McKane?
Yes.
Okay. And do you see Mr. McKane in the courtroom?
Yes.
Could you point him out and describe what he's wearing, please?
Right over there with the glasses on.
Okay. Mr. Hill, if this person is number 1, this person is number 2, number 3, and number 4, which one would Otis McKane be?
Number 4.
All right, thank you. Let the record reflect that Mr. Hill has identified the defendant. Mr. Hill, Can you tell the members of the jury about the first time you met Otis McKane, please?
I was at a family gathering. I think it was about Thanksgiving. And my daughter brought him to the house and introduced us to him. And my wife's cousin from out of town was there with some more relatives. And they was asking him, what do you do? Where do you work at?
And let me stop you for a second. So it sounds like this is a larger family gathering?
Oh, yes.
Okay. And when you say that they were asking, you're talking about some of the men in the family were asking Otis McKane, what do you do or where do you work at?
Yes.
Okay. Were you also interested in that since this man was supposedly now seeing your daughter?
Yes, of course.
Okay. And so when you asked him that question, what did he tell you?
He told me that he didn't have a job because he was on probation for selling crack.
Did that make you happy?
Of course not.
Did the two of them begin a relationship then, as far as you were aware?
I guess, as far as I know.
Okay. And in the entire time you knew Otis McKane, did you ever know him to have any kind of steady employment?
Big pardons?
The whole time you knew him when he was dating your daughter, Saharia, did you ever know him to have steady employment?
Not that I know of.
Did you ever know him to even have a car?
No.
Now, was Saharia living with you back in 2009 when she first met the defendant? Was your daughter living on the property with you and your wife?
Not at the time.
Did there come a time where she did move onto the property with y'all?
Yes.
Okay. And can you tell us why that happened?
She was threatened.
Okay. When you say she was threatened, who was she threatened by?
I'm going to object to hearsay, Your Honor.
Otis McKane.
Hold on a second, sir. Response? We hearsay objection.
Your Honor, that is a, okay, it's not a hearsay, I'm not asking him what did she say. He said that she was threatened. I think if he's got personal knowledge of that, he can testify to that. He's not saying what his daughter said.
Well, why don't you ask him the foundational question?
All right. Mr. Hill, what was it, and were you hearing about what this relationship was like from your daughter?
Well, off and on, like I said, I was working at the time, and like I said, a lot of times I wasn't around the house at that time.
Did you ever hear from your wife about what the relationship was like between your daughter and Otis McKane?
Well, a little bit.
Hearsay, Your Honor.
I'm going to overrule that for that specific question.
A little bit.
That was a yes or no question, sir.
Now, at some point, did you find out that fairly early in their relationship that your daughter was pregnant?
Eventually I found out, yes. It came to me and it said, it made a statement out of it, that she was pregnant.
How many, from the time that you first met Otis McKane that you already described to the jury, to the time that you found out that your daughter was pregnant, do you know about how many times you may have seen him in that time period?
I can't recall on that.
At some point, did your daughter deliver a child?
Yes.
All right. And what is the name of the child that your daughter delivered? What's
I'd
the
rather not
child's
say
name?
it.
Okay. Is the father of the child Otis McKane?
Yes.
Who has raised that child? Who's been the man in that child's life since 2012?
Me. Who's been my wife?
Who's provided financial responsibility besides Saharia? Would it be you and your wife?
Family.
As far as you know, has Otis McKane, the defendant, in the last several years provided one penny to your grandson?
Oh, not to my knowledge, I can't say.
Let's take I want to take you back to the hospital the day your grandson was born. Do you remember that day, sir?
Yes.
Okay. And once your grandson was born, did you see Otis McKane show up at the hospital?
Yes.
Did he show up by himself or did he show up with someone else?
By himself.
All right. And was it a happy occasion when he showed up for the birth of his son?
No, I wouldn't say no.
Can you describe for the members of the jury what happened when Otis McKane showed up at the hospital?
Well, we got into an argument about, I can't remember what exactly it was, but there was a lot of friction going on. So, and a lot of volume getting loud, and to the point where almost had to call the security guard to try to, because there was other people in the hospital too.
Did when he showed up that day, did he believe that your grandson?
I'm going to reject the leading.
Does that answer the question?
Was there a question in the mind of Otis McKane as expressed to you about whether or not he was the father?
I'm going to object to leading and hearsay and lack of personal knowledge.
It's not hearsay, it's admission of a party opponent, it's his client.
So ask him that question directly then if it's an admission.
Did Otis McKane make a statement to you about whether or not he was the father of your grandson?
I recall that he didn't say the baby was too light-skinned to be his.
Was he asking for a DNA test on the child?
He had brought that up. Yes.
Did he hold the child?
Your Honor, I'm going to object to the continuous leading questions.
All right, so as it relates to this last question, I'll overrule.
Did he hold your grandson the day your grandson was born at the hospital?
Not today, I don't think, but he eventually did. In the
Eventually.
hospital, yeah, we did.
Now, after the child was born, you mentioned that your daughter moved back home. Is that correct?
During the time of safety measures, she stayed with the family.
Okay. And why, when you say safety measures, what do you mean?
Like, when they had a confrontation with him, with Otis McKane.
And what do you mean by confrontation? Can you tell the members of
Well,
the jury?
this was when I believe she can tell you better than I can. I know that one time that she had brought my grandson. She had to take him to visit him at one time, and that's when they got a little something happened. Something they had to call.
Objection to lack of personal knowledge, Your Honor.
All right. I'll sustain that. Let's get the next question.
Did it ever come to your personal knowledge that there was an assault?
Well, Your Honor, I'm going to object to leading and backdoor hearsay.
I'll sustain.
Did you ever confront Otis McKane about having threatening or the safety of your daughter? Did you ever talk to him about that?
No, because he was never around at that time.
At some point, was there a protective order against him?
I believe so.
Did you tell him not to go to your property?
I told him to stay away from my property at one time. He did come trying to get onto my property. Yeah, so I confronted him, let him know, hey, you're not wanted here, you're trespassing. I got a trespassing sign on my gate.
Did you have a gate on your property before you met Otis McKane?
I had a fence.
And did you change that out after you met Otis McKane to put up an iron gate?
Well, I think it was eventually, I had two gates I had.
Did he come to your home once or more than once when he was unwanted out there?
More than once.
Can you recall about how many times, Mr. Hill?
3 or 4 times, I think. I'm not quite sure about the numbers, to be exact.
And when that happened, would you contact the authorities?
Oh, yes.
And each time, did you tell him he was not wanted on your property?
Yes, yes.
Did there come a time that, and when Mr. McKane would show up out there at your property, to your knowledge, how did he get out there? Did he drive out there in a vehicle, or did he walk?
I really don't know.
Okay.
There wasn't a vehicle nowhere out in front, so I really don't know.
I want to direct your attention to McDonald's, an incident at the McDonald's. Are you with me? Do you know what I'm talking about?
Yes.
The incident at the McDonald's?
Yes.
Okay. Can you tell the members of the jury what happened that day at the McDonald's?
Well, my daughter called me saying that she was having problems with Otis McKane. So I went up to the McDonald's in the parking lot. Well, he had my grandson in his hand. I wouldn't let him go because my daughter, there was still friction going on. My daughter was ready to leave, and he didn't want to let my grandson go.
Now, what were emotions like when you showed up out there at the McDonald's parking lot? Was everybody just happy and smiling, or what were things like when you got out there?
Well, I said the people inside McDonald's that was happening. I was more focused on him. I was more like a tunnel vision. I was zeroing on him. He was had my grandson like this, like, and just running all around the parking lot. I'm right behind him, pursuing him to catch him. I finally catch up with him and get him in a chokehold to release my grandson.
About how old was your grandson at the time?
He was a toddler, I think.
All right.
Might have been 4, something 3 or 4.
And you're sort of making a gesture with your right arm, almost like maybe somebody's holding a football. Is that?
That's what he had. Like, a grip. Had a grip on him.
Okay. So your grandson, the toddler, was he holding him with one arm or both arms?
I think he might have. At first, I think he had both arms, and then I don't know. So much going on at the moment.
Right. When you showed up, why was he running around in the parking lot? To your knowledge, do you know why he was running around?
No, I was pursuing him. I was going after him.
Why were you pursuing him?
Because he wouldn't let my grandson go, and he was crying.
When you say he was crying, do you mean your grandson or Otis McKane?
My grandson. Well, I really don't know what was kicking off, what started the whole thing with him, but yeah, he was.
Did you ask him to let your grandson go?
Yes.
Did you ask him to?
I'm going to object to the leading nature of the question.
Overruled.
Did you ask him to give your grandson to your daughter or to yourself?
Just told him let him go, give him back to him.
And did he do that?
Nope. He didn't do it until I got it in the headlock. Then he had to release him.
What was Otis McKane's demeanor like, or what was he like out there when you were confronting him? Can you tell the members of the jury?
All hyped up. All hyped up.
Was he saying anything to you?
But the time he let my grandson go, yeah, he's profanity towards me and stuff,
Can you, so the members of the jury know, can you tell the members of the jury what kind of profanity he was using towards you, the father of his son, the grandfather of his son? What kind of profanity was he using?
So come on, motherfucker, come on, nigga, come on. Backpedal, do that, come on.
You've got your both fists raised as if he was saying, you want to fight? Is that correct?
Exactly.
After that incident at the McDonald's, Mr. Hill, have you ever seen Otis McKane again?
Let me see, yes it was. Yes, I saw him at one time at school. at the school where my grandson was going at the time. And he came up there for, I guess, a visit that I didn't know nothing about. I don't think my daughter knew anything about license. I think he had that right, I believe. So it wasn't a big issue, though. But he couldn't take him from the school without her permission. And he was not authorized to do that.
Did you ever meet Otis McKane's mother?
Yes.
Did she know where y'all lived out there on the east side?
I'm not sure.
Okay. Are y'all still today, without telling me the address, are you still in the same home that Otis McKane visited back in the years 2009 to 2012?
Yes.
Thank you, Mr. Hill. They may have some questions for you, sir.
Mr. Hill.
Will you speak up, please?
Yes, sir, Mr. Hill. Can you hear me, sir?
A little louder, please.
Okay. Mr. Hill, my name's Joel Pettis, and I'm one of the lawyers that represents Mr. McKane here to my right. Would it be fair to say that your daughter, Sahara, got pregnant fairly quickly into the relationship with Mr. McKane?
Will you repeat that?
That your daughter, Sahara, got pregnant fairly quickly into the relationship with Mr. McKane?
Oh, no. Well, I don't know how you put that. I wouldn't know.
Okay, that's fine. Now, you testified that you never, and I'm not saying that it's not right or wrong, but you never knew whether or not Mr. McKane was working.
Can you say that again?
Did you ever know if Mr. McKane had jobs?
Oh, we understand what you're saying.
Did you know if Mr. McKane ever had jobs? Was working?
Oh, no.
No, okay. But that doesn't mean he wasn't working that you know of, right?
Well, you have some questions. I didn't know.
Yeah. You didn't live with Mr. McKane or with Miss Sahara, right, your daughter? You didn't live with them?
No.
So you didn't know the day-to-day activity of Mr. McKane generally, right? On a daily basis, you didn't know what he did?
No.
Okay. Now, you said that there was some disagreements at the hospital with regards to whether or not the child was Mr. McKane's, right?
Yes.
That was the disagreement, right?
Well, he said the baby's too light to be his. That's what he said.
Okay. Now, at some point, you decided, or Sahara moved in with you at your property, correct?
For safety measures. For safety measures.
Oh, of course, sir. But so Mr. McKane, over the span of a couple of years, tried to see his child, and you said he went over there on 3 or 4 occasions.
2 years.
Okay, months.
I couldn't say.
Okay, that's fine. But he went over there trying to see his child.
Oh, before that, he tried to come over.
Okay.
Before that.
Now, with regards to the incident at the McDonald's, you don't know what transpired or what happened before your arrival. You weren't there.
I wasn't there.
Okay. And so by the time you get there, things are already happening, right?
He's in the parking lot. Was she trying to tell him to give my grandson up?
Sure.
To her. Yeah.
Sure. And during that time, you wouldn't know, unless you remember specifically, whether he had any visitation with the child? You wouldn't know what the court order said?
Say again?
Well, you don't know if it was his time of possession with the child, do you?
Oh, I believe she can tell you that better than I could.
Sahara could tell us, but not you, right? Okay, now, you testified that I guess at some point Mr. McCain wanted to keep his child and you wanted the child back, and so you started, like, I guess, chasing him or something like that, right?
He wouldn't let my grandson go, and therefore I pursued it.
Yes, sir. And and I mean this with all due respect, sir. How old are you?
I'm 72.
Okay. And so Mr. McCain, you said at some point you made this expression, he's holding the child with both hands, both arms, and you at this point are, I guess, chasing him in this parking lot, correct?
I was chasing him around the parking lot trying to get him away from my son.
Yes, sir. Yes, sir. And but yet you were able to, I guess, overcome Mr. McCain and hold him in a chokehold and take, I guess, the child to your possession. Is that what happened, sir?
I was 72 at that time. But yes, caught up with him and
Yes, sir. Thank you very much, Mr. Hill, for your time, sir.
Thank you, sir. I appreciate it.
All right, sir, you're excused. Can you approach? All right, State, call your next witness.
Your Honor, this time the state calls Sahara Caleb Hill.
You can have a seat, man. I'm going to swear you in, okay? Do you solemnly swear or affirm that the testimony you give in this trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. You can remove. If you can introduce yourself to the jury and spell your name for the court reporter, please.
My name is Sahara. It's spelled Sahara.
Last name?
PAILLETT -HILL.
All right, State.
Thank you, Your Honor. Sahara, would you please introduce yourself to the jury?
Oh, yes. My name is Sahara Hill. I am the ex-girlfriend of Otis McKane.
And Sahara, when did you meet Otis McKane?
About 2009.
And how did you meet him?
Met through a mutual friend.
And you said sometime in 2009?
Yes.
Okay, and when y'all met, did y'all become friends first and then you began dating? Can you tell us a little bit about the beginning of your relationship?
In the beginning, we were still trying to get to know each other. At the time, he was working, so had to go through work with his schedule at the time.
And where was he working at the time, back in 2009?
He was working at McDonald's.
And so then when y'all started, you said you had to kind of go through his work schedule because he was working. Did y'all begin dating at some point in 2009?
At some point, we did begin dating.
And then when did you find out that you were pregnant?
Pretty much later in a year.
And
I think
that
around like sometime like around fall.
Fall of 2009? And did you, so you eventually gave birth to a son, is that correct?
Yes, that's correct.
And when did you give birth to your son?
June 2nd.
Of 2010?
Yes.
And how would you say your relationship was with Otis McKane prior to your son being born?
It was, I didn't really pay attention to some of the red flags, but it was so-and-so relationship.
It was what, I'm sorry?
It was in so-and-so relationship. It was just that he depended on me more, seeing as he has a job. At the time, I didn't have a job, so.
And so during that time, you said you didn't have a job. Were you going to school?
I was actually going to school like when I was pregnant and then after I delivered my child.
Okay. And where were you going to school?
I'd rather not say.
Okay. But were you...
Yes, I was in college.
Okay, and that was my question. Were you going to college? Is that right? You were going to college?
Yes.
Okay. And so you said your relationship was so-so, that you didn't pick up on some of the red flags?
Yes.
And what were some of the red flags that you're referring to?
It was that he expected more from me. He expected me to pick him up and take him to work and to arrive on time, to show up in a timely manner. And if I didn't show up, he didn't like that at all.
And when he didn't like that, how would he express that to you?
He wouldn't state it. He would mention that to me. And it pretty much like a little bit of verbal abuse as well. It just probably brought me down.
Now, the child that you had in June, you said June 2nd of 2010, is the father of that child today?
Yes.
Okay. Would you please describe what he's wearing and tell us where he's seated?
He's going to say right over there. He's wearing glasses. He has a beard.
Okay. And right over there, if you look towards, I guess your left, where is he seated at the table? There's
far on the left.
Okay. And for the record, you've identified the defendant, Otis McKane?
Yes, I recognize his facial features as well.
So when you gave birth to your son, did the defendant come to the hospital?
He did, because at the time I was about to go to delivery, and I choose not to let him go.
And
he didn't go to the room with me.
Okay. And why is that?
It's just that I didn't feel like the need that he needed to be there with me. I chose somebody else.
Okay, and who did you choose?
I'd rather not answer.
Okay, so a family member of yours?
But yes, a family member.
Okay, and and you said the defendant came to the hospital, or Otis McKane came to the hospital?
Yes.
And is there anything that he said that you recall about your son, or about y'all's son?
Yes, about his appearance. Like, he's light-skinned, he looks lighter, he doesn't look like me. Because according to him, he's dark-skinned, but the baby was light-skinned. So he started to question and have doubts about whether or not my child is his.
And was there any doubt in your mind that your son was yours with Otis?
Oh, I was 100% sure that he is the father.
100%
I was sure, because I was not with anybody else.
Okay. And so he was having doubts and expressing that. Did he want to take a paternity test to confirm?
Oh, he did. He did took a test for his sake.
Okay.
I just didn't like the sound of it, but he took it and he found out, and the truth came out that it is his. So there you go.
All right. Now, up until this time, up until you had your son in June of 2010, had you and the defendant lived together?
No. He offered for me to move in with him at one point, but I refused.
And why did you refuse?
Because I felt like I didn't think it was a good idea at all. After seeing what I dealt with him within the relationship on and off again, it wasn't worth it. And it would just lead to more problems.
Now, were there times after your son was born, and when I say your son, I mean the son that you had with the defendant. Is that your only child?
Yes, that's my own child.
Okay. And was there times after your son was born that you and that the defendant, that you had to call the police on the defendant?
Yes, there's been a few incidents that happened.
Okay. Have he ever been physically violent with you?
Yes.
Okay. Has he ever been verbally abusive for you?
Yes.
So after your son was born, how would you describe then, the paternity test came back and it showed that the defendant was the father. How would you describe your relationship at that point? Now, we're in June 2010 going through, I guess beginning from summer to fall of 2010.
Well, he really wanted to see his son. He wanted to do his best to prove that he could be a father to my son. But even the fact that he couldn't keep a steady job, he couldn't hold a job, and along with both financial issues and other struggles along the way, he was having a hard time to do so.
Okay. Was he providing for your son?
He tried to provide. Like, he even tried to get an apartment for us, but that didn't really last long either.
Okay. And why didn't it last long? Do you know?
I'm just assuming it was financial issues.
Were there times in your relationship with him that he thought you were cheating on him?
Yes.
Okay. And how did he express that towards you?
Very, in a way that he would make accusations, and he would think so much that, oh, maybe you're cheating on me with my friends, right? Maybe you're cheating on me with somebody else. And it was at a certain point that he even got a hold of my phone and looked through the contacts and just started questioning them, like, how do you know me? How do you know my girlfriend? Et cetera, et cetera.
That he would question?
He was questioning them. Like, he would go through my cell phone and go through my contacts and question them.
Okay. So I want to go to April 25th of 2011. Was there a time that you had to get, or that you decided to get a protective order against the defendant? I guess it started out as a temporary protective order and then moved to a protective order.
Yes.
Okay. Do you recall when that was?
That was around in January. The earliest January, about 2012.
Okay, January of 2012. And so based on the in order to get the protective order, did you provide an affidavit to be filed with that protective order describing the verbal and physical abuse at the hands of the defendant?
There were several files, there were several reports I made, so I can't really be sure.
Okay, you're not sure the exact time or
Yeah.
date? Okay. You're on an approach.
Yes.
Ms. Palin Hill, Pyatt Hill, is I saying it right? Pyatt? Okay. I'm going to show you what's been marked as State's Exhibit 389, a court document, temporary ex parte protective order, and show cause order, and attached is what appears to be an affidavit. That's connected to the protective order, is that correct?
Yes.
So why did you feel like you needed to get a protective order against the defendant?
For once, I was like, one thing I could say is I was very scared. I was terrified. It was not for my life and for my son's.
And so why were you terrified for both your life and your son's life? What had occurred in order for you to have fear or to be scared of the defendant?
Like one of the most scariest incidents that happened was when me, Otis, and my child were in a car, and we were on a road. We were on an access way. There was
an access way, meaning the
like not on a freeway, but on the side.
Okay, like the feeder road,
Yes.
the access road to
Yes.
a highway. Okay.
And at that time, there was a big disagreement. It was just so horrible. It really, I can never forget about that moment. It was just so shocking to me that he would do such a thing. I was pretty much the driver. On the side of me, Otis was on the passenger side, and then my child was in the back seat.
Okay.
And at the time, while we were on the road, and we were having like this argument, he suddenly grabbed a hold of the steering wheel, and he was immediately trying to get us off the road, trying to crash us into a ditch or so.
And how old was your son at this time?
He was a baby.
Okay. So he's in the back seat. Is he in a car seat?
Yes, he was in a car seat, secured and everything.
And so he's in the back seat, you're driving, and Otis, the defendant, is in the front
He was in the passenger front, yes.
passenger seat. And so what led to him? You said we were in an argument or we were arguing. What were y'all arguing about?
I'm pretty sure it's just the same old things. It's just getting back together, whether it's getting back together or seeing his son more or trying to change for the better. But it was just a never-ending cycle.
And you said, like in this never-ending cycle, did that seem to be a regular argument that the two of y'all would have about wanting to like break up, get back together, wanting to see his son, and then he would do something either to you that would cause you to fear him?
Yeah, it was like whether it was just miscommunication or a misunderstanding.
And so, did you want to get back together with him?
No, absolutely not. I kept reminding, even through text, even in person, but that's not what he wanted.
And what did you keep reminding him?
That I just kept reminding him about my son. That just be responsible enough to pay child support and just focus on him, not me.
To focus on being a father as
Yeah,
opposed
to being a father figure.
Okay, so you're telling the defendant to focus on being a father to
Yeah,
your son?
being responsible.
Okay,
being a responsible
Hang on,
parent.
hang on. No.
Oh, sorry.
It's okay. I just need one at a time, so let her finish the question. Thank you so much.
Instead of the defendant focused on getting back together with you. Is that a fair statement?
Yes.
Okay. And so, do you recall when this was, or approximately when this was, this incident you're describing on the access road?
I know that also happened around in January, which was one of the reasons why I hadn't gotten a protective order.
In January of 2012? So your son would have been like a year and a few months, maybe a year and a
Yes.
half or so?
Yeah.
Does that sound right?
Yes.
Okay. And so, can you tell us what caused him, or why did he start grabbing the steering wheel?
Because he was angry. His behavior just changed automatically. It was like if things didn't go his way, he'll try to figure out a way to do so. So he was just enraged. He didn't like what I was saying, and he wanted to just take control.
Okay. And so what were you saying then? What made him so angry? The fact that you didn't want to get back together with him?
The fact that whatever like he needs, and if I'm not able to do so, or able to do that, or do what he wants, he gets mad.
Okay. And he expressed his anger by putting your life, your son's life, in danger?
Yes.
Okay. And so how fast were you driving somewhere?
I wasn't really driving. I was sure driving alone. I would say like about 20, 30.
Okay. 20, 30 miles per hour?
Yeah. It wasn't really that fast because there wasn't much traffic.
And so when he grabbed the steering wheel, and what did he do after he grabbed the steering wheel? What did he do with
He was trying to like let us crash, like just let's get us off the road, but he couldn't really crash or worse. And it was just so scary at that moment. I was trying my best to calm down and just trying not to freak out.
Okay. And what was he saying during this time to you?
He was so angry and frustrated that he threatened to kill me. And not only that, he endangered me and my son and himself.
Right.
It was just, you just couldn't help but think, why would you do that? Why would you risk putting our lives in danger?
And the statements that he's making, did you record those statements?
Yes.
Okay. And why did you record the statements?
Because there was so many signs that his behavior wasn't changing. It was pretty much the same. He was always angry. He was always frustrated, and I wanted to pretty much show proof that for myself that I'm better than this. This shouldn't happen to me. This shouldn't happen to anybody.
And when he becomes angry and frustrated, does he act out on his anger and frustration?
He does.
Towards others?
I wouldn't say to others, but I see it mostly from me. Like he does it to me, or in this case, like he would just take a hold of my son and just like take him away from me.
Okay. Yeah, and you're only speaking. I mean, that's what I meant. Others, like you're only speaking about your relationship with Otis McKane,
Yes.
right? Okay.
Yes.
And so you said you recorded what he was saying, and it came out on 2 recordings. Is that right?
Yeah, it just came from my old phone.
Okay. And you had an opportunity, you provided those recordings to us?
Yes.
And you had an opportunity to listen to them?
Yes.
Your Honor, may I approach?
Yes.
I'm going to show you what's been marked as State's Exhibit 387 and 388. Did you listen to both of these recordings?
Yes, ma'am.
Okay, and did you put your initials on each one?
Yes, ma'am.
And the date in which you listened to them?
Yes, ma'am.
Okay, thank you. And do these recordings, State's Exhibits 387 and 388, do they fairly and accurately show the conversation between you and the defendant in the incident that you just described to the jury when he was grabbing the steering wheel as you were driving down the access road?
Yes, you can even hear the sounds like in the background. I mean, it's so loud you can hear it.
Your Honor, this time the State moves to introduce State's Exhibits 387 and 388.
No objection.
All right, they're admitted.
So this time we're going to publish State's Exhibit 387. And had you been recording, or you started the recording at what point during the conversation?
Right around the time when his tone changed,
Okay.
like from his normal tone to his angry tone to his harsh tone, and it's just, and his voice got louder.
So this you said was around January or so of 2012?
Yes, I believe so.
So the two voices on this recording are your voice and the voice of the defendant, Otis McKane. Is that correct?
Yes.
On both of these, State's Exhibit 387 and 388. defendant goes at times from crying to then yelling at you. Is that fair to say?
Yes, to being irrational.
Okay. And what is he saying? It's, at times it's kind of hard to understand. What is he saying to you?
He said, well, I know certain parts of hers that I want to see my son, I'm doing this for my son. He's always mentioning it all about my son.
Okay, but his son's in the back seat during this time?
My son, yeah.
Oh, your son, y'all's son together
Yes.
in the back seat
Yes.
when this is going on?
Yes.
Okay. And then the recording continues?
Yes.
Okay. And that states Exhibit 388. Transcript of the second call. We had it done by criminal district courts, by Sergio Conte, for criminal district courts translators. And so we provided that to the defense. We would like to provide a copy of this for the jury to see while they listen to it. I think it'll assist them in being able to understand what is said.
Can we approach, Judge?
Yes.
Okay, and again, the voices on that first one that the jury heard, State's Exhibit 387 is your voice and the defendant's voice?
Yes.
Okay, and only, is that right?
Yes.
And then on this one, the second recording from the same incident when you were driving on the access road, State's Exhibit 388, it's your voice and the defendant's voice?
That's
only?
correct.
I'll kill you. Do you recall that?
Yes.
He called you a.
Objection to leaving, Your Honor.
Well, the jury heard, do you recall what he called you? He's calling you names throughout this. What are some of the things he's calling you?
Bitch, nigga.
And how does that make you feel?
It's very degrading.
And are you trying to calm him down or reason with him?
Yes.
Okay, and are you able to do that?
I did what I could at that time while trying to calm myself down because I was, given the fact that what happened, in the midst of the panic, I was trying to calm him down. Because if I can calm him down, then we would be able to manage to get off the road and like go to our destination.
And what got him to this point?
Perhaps so much tension, frustration, like struggles that's been bothering him throughout at that time.
Like struggles with your relationship with him?
For one, yes. One, probably other things, the factors that's going on with him.
Okay. And so he's threatening to take your life?
Yes.
Okay. And so does he, so at the beginning he says, I'm going to kill you, and then near the end of the recording, does he bring it up again?
Yes.
Okay. And how does he say it then?
Oh, you'll end up in a ditch, nigga. He and with such tone and force in his voice.
And did you believe that he had the capability of carrying it out?
Yes, I mean at that point in time, yes, that too. And it stood by me, just wondering what if he's capable of doing so, of taking my life. I mean, he endangered my life.
I'm going to object to which one of these attorneys are making the objection. They both seem to chime in, and so I would just ask that under the local rules, one of them question the witness. Or make
Well,
a judgment.
according to the state code, Your Honor, he's entitled to 2 lawyers representing him at all times.
Yeah, and it's been going on the whole trial. Let's go and get the next question.
And so you were saying it kind of at the end of the conversation, that he was saying about taking your life. He said, I'm not leaving by myself. Do you recall that?
Mm-hmm.
And what did that refer to? I'm not leaving by myself.
Like I'm not going down. I'm not going down myself. I'm not gonna be the one to blame or pretty much be the one that ends up failing, being destroyed and all that. Like, because I know at that time we had.
I'm objecting to the non-responsive nature.
Next question.
Okay. So when he says, you better fucking start talking, what is he talking about?
He's talking about what was going on with me. Seeing as we were on and off again relationship at that time, we broke up. So he wanted to know what was going on with me, if I'm dating somebody, or what am I up to? Am I going to school?
Okay. And so then the recording ends. How does the recording end?
It just ended with us pretty much heading to where he needed to go, whether it be to his grandmother's house or to another destination.
Okay. And so is the recording only for a certain period of time, and then it stops and you have to start the recording again?
It was just to stop, because it would have been very a long, extended amount of time. Like it could have been up to an hour, so I had to cut it off.
Of the same conversation?
Oh, I'm just saying I just had to cut off because it would have been too long to listen to.
Okay.
Because I didn't have enough memory in that time on the phone.
So at this point, so somehow you were able to, were you able to kind of get control of the situation, or what diffused him?
Just talking to him, needed to open up to him.
So, and you said this was in January of 2012?
Yes.
Also, in January of 2012, there was an incident between you and the defendant at the Walmart. Is that correct?
Yes.
January 22nd of 2012?
Yes.
Can you tell the jury about that?
Oh no, that one was regarding to me paying him back for some money, even though I had him on child support. So he was really strict about getting his money back.
So you owed him what, $20?
About $20, yeah.
Okay, and so tell us about that. He was strict about getting his $20 back from you?
Yes, because I'm not sure what his intentions were with the $20 if I gave it to him at that time. So, I know I had my card for the child support, but it's because I was telling him I was going to go to the ATM. But at that time, they decided, you know what? No, the child support is meant for my child. It's not meant for him. So I went back to Otis and I told him that I will get you your money as soon as I go to my house.
Okay. And
But-
so were you all at the Walmart at this
Yes, at the point.
point? Okay. And so when you told him that you would go to your house to get the $20 of the money to pay him back, was he okay with that?
Absolutely not.
Okay. So what happened?
It's like he wanted the money right then and there. He got so mad that he started to count down. Like count down to 5, 4, 3, 2, 1. Like as if he was about to strike or he was about to do something.
Okay.
So as he's counting down, I got pretty nervous, so I had to get out of the car because I didn't know what he was going to do. Seeing as like previous times he would hit me or attack me. So once I got out of the car and he went count down to 1, he went after me. He got out of the car and went after me.
Okay. And so you had gotten out of the car. Were you driving or were you in the
Oh no, it was parked.
Okay, so right, I guess had you driven there or were you the passenger?
Oh, we drove there. I drove there.
You drove
It was my
there.
car.
Okay, so you get out. He starts counting down, and are you concerned about what may happen when he gets down to 1?
Yes.
And what are you thinking may happen when he gets to 1?
I feared that he was going to come after me.
Okay, and did he come after you?
Yes, he did.
Okay, so you get out of the car as he's counting down 5, 4, 3, 2, 1, and do you walk away? Do you run away? What do you do?
I immediately got out of the car and I was trying to like back away from him. So as soon as he got out of the car, he was chasing after me and he attacked me.
Okay, and when you say he attacked you, what did he do?
Like he left bruises on my face and even like got me in a choking around my neck.
And so you said he left bruises on your face. How did he do that?
He attacked me. He actually hit me.
Okay, so he hit you?
Yes.
And where did he hit you?
Around the face.
And so had you done anything to him or said anything to him? I mean, he just starts counting down because you're not giving him the $20?
Yes, it was just he wanted the money right then and there. Like if I couldn't give it to him, he would find a way. It's like he wasn't patient. He didn't want to wait. He went for me to go and just get the money from him.
Okay. So you said he hit you in the face?
Yes.
Did he hit you with a punch or a strike, a slap, a punch? Do you recall?
It was with his fist.
Okay. And where did he hit you on your face?
It was either the left or the right. I can't vaguely remember, but I know it was just so bad that my face swelled up.
Did it hurt?
Yes, it did hurt.
And so you said also on your chest area as well?
I had bruising about the chest area as well, but it was more on my face that was more serious than anywhere else.
And so you said that he also put you in a chokehold.
Yeah, like he was choking me with his hands. It was like this,
And,
like making it difficult to breathe.
okay. And were you scared?
Yes, I was scared, terrified.
And so what are you scared that's going to happen?
I'm scared that my life could end right then and there. I'm scared that he's not going to stop.
And is this after the driving incident that we just heard on State's Exhibit 388 where he's saying, I'm going to kill you?
With the time, I'm not sure. It was probably after. I'm not too sure.
What was after? The Walmart?
Yeah, Walmart.
Okay.
I know there was more than one incident.
Okay. And so so he has you in a chokehold. Are you able to breathe?
I was having difficulty breathing.
And what is he saying to you during this time?
Because I want answers. He just wanted to know about the money. That's all he was caring about right at that point.
And what did you owe him $20 for, if you even remember?
I really don't remember. I think maybe it was for gas money. It was just something, just minimal.
Okay. And so he punched you in the face. He put you in a chokehold, or was attempting to choke you. How did you get away from him?
Somehow, I know it's been a long time since that happened. Somehow, either he let go or either I defended myself.
And did you call the police?
Oh, the cops were, the cops came.
And what happened when the police came? Well, did they arrest the defendant? Did he get arrested?
Both of us were questioning about what happened.
Okay.
So,
And, sure. But did he end up getting arrested for this?
I believe so.
Your Honor, this time the state moves to introduce State's Exhibits 383, 384, and 385. And additionally, and 386. Was it 3? Right.
No objection, Your Honor.
All right, they're admitted.
Your Honor, may I approach?
Yes.
So specifically looking at State's Exhibit 384, it's a judgment here, a criminal judgment for Bexar County, State of Texas versus Otis McKane, cause number 382843. The offense date is January 22nd of 2012. Is this the incident you just described to the jury, the assault that occurred on you by the defendant, where you're the victim in the case?
Yes.
Okay. And it has the information as to what allegedly happened. Is that correct?
Correct.
Okay. And the defendant, are you aware, was sentenced to 60 days in the Bexar County Jail for that assault?
I was informed that he was in jail because I remembered that I got a call from the jail. More than likely was always mentioning the bail amount.
I'm sorry, I didn't
Mentioning the bail amount.
Oh, mentioning the bail amount.
Yeah.
And who called you?
Otis.
And what was the purpose of the call?
It was just that, seeing as you knew my number, he was trying to reach out to me just to mention about bailing him out. I think it was just because I didn't want to answer it. I didn't want to talk to him whatsoever.
Okay. And you said you knew he was in jail. Did you know he ended up pleading to this offense for assaulting you on January 22nd of 2012? Did you know that? Is that you?
Yes.
Okay, I'm sorry. The court reporter can't take that
Yes,
on.
I'm sorry.
That's why I asked you again. And then there was an affirmative finding of family violence that was made by the judge.
Yes.
And that was based on the dating relationship, meaning that the two of y'all shared a child and the assault occurred within that.
That's correct.
Okay. And so now, have there been other incidences of violence that you've experienced at the hands of the defendant?
Yes.
Okay. Can you tell the jury about another one?
Another one was at the time when I was in
Moment, Judge.
Yes.
Another time was when I was dropping my son off. I think it was due to visitation over at his grandma, seeing as Otis was there. So when I did, I I know it was something escalated to the point where he took off my hairpiece. Like he took my wig off more than once. The first one time when I dropped him off, and then when I came back to pick my son up, when he put my son in the car, he immediately grabbed my second hairpiece off my head and threw it in the dumpster.
So you were sitting in the car?
Yes,
Okay.
because I was just there to pick up my son and drop him off.
And so how did that occur? Like he reached in and grabbed your hairpiece?
Yes, I had the windows down at the time. He was putting my son in the back seat, like he was supposed to, and locked and like this secure and everything else. And then all of a sudden, without, I was caught off guard. Like he immediately just snatched, like really just grabbed it from my top of my head, just to humiliate me.
Okay. And were there other people around watching?
I know with another incident that happened, yes. I know with that time, I know there was a neighbor or so that noticed that, they just couldn't help just laugh it off.
A neighbor did?
Yeah.
Uh-huh. And so again, you said, it made you feel humiliated?
Yeah, humiliated, hurt, pain.
Okay. And what was had you said anything to him, or had there been an argument? I'm trying to understand. He just reached in and grabbed your hairpiece and threw it?
Judge, I'm going to
Is that
object to the leading and the testifying by the prosecutor.
Or else sustain.
You sustained the objection.
Yes, I did.
I said, I was getting ready to ask my next question.
Yes.
Mr. Clemens. So tell the jury then what led up to that time.
What led up to it was just that it was just wanting him to see his son and me, like pretty much taking my son over and just dropping him off, picking him up. This is the time when we have visitations.
Okay. And so there were visitations. You said it was the time when we had visitations?
Yes.
And so you would take your son over to his house or his grandmother's house or his mother's house?
It was either at his grandmother's house or his mom's house. Most of the time it was them. It was either those two destinations.
And on two of those occasions is when you said he did what? Well, I'm trying not to believe them. I'm not. I'm trying to ask a question without getting an objection. Actually. So you were talking about the acts that he did, the defendant did, that humiliated you.
Well, Your Honor, that's been asked and answered, Your Honor. She just established the prelude to that it's been asked and answered twice already.
She said there were two occasions, Your Honor.
She testified to both of them, Your Honor.
Overruled.
You can answer the question.
Okay. I know with another incident that happened was also the one over McDonald's. I know that was regarding the visitation as well, and that was on the 5th Sunday. Because I know we were over visitation. He was allowed to see my son the 1st, 3rd, and 5th.
Sorry, I thought you were finished.
And with that being in mind, when I took him over to see him over at McDonald's for a visitation, he didn't really want to spend time with my son. He wanted to see what I was up to. He was trying to figure out.
William, object. This is speculation on her part.
Okay, you get the next question.
Did it appear at the incident you're referring to is the one that occurred at McDonald's?
Yes.
And when was that, if you can recall, approximately?
Around 2014.
Around 2014? Okay. And you said, let me ask it this way, did it appear that he wanted to spend time with your son?
He was watching him, but he was talking to me more.
Okay. And talking to you instead of doing what? Or what gave you that impression?
It was just that seeing as my son was in a play place, he was playing around. Pretty much, I was sitting down. I was trying to just keep away from Otis, but he wanted to know what was going on with me, what I was up to.
Okay. And so, what happened after that?
Things escalated to the point where I had to take out a recorder to show proof.
Objections is not responsive, and the question was very open-ended.
All right, next question.
You said things escalated. How did they escalate?
Not so well at all. It was to the point where I had to take my son and have to go to the back of the restroom and to mention to the manager over at McDonald's to call the cops.
And so what does that mean, though? You said they escalate. Did they escalate verbally? Or
Verbally, yes, verbally.
Okay. So what was the defendant saying to you if you can recall?
I can't recall everything. It's just I know that it was back to his tone, and he was to the point where he wanted to take my son away from me.
And so what happened next? You said you told the manager to call the police?
Yes, or at least someone heard me like yelling, "Please call the police!" About it. Well, the cops did call, and then somehow the three of us, me, my son, and Otis, were outside because he eventually got a hold of my son. He was going to start to take him to over to his mom's house or somewhere else.
So he grabbed a hold. So your son now would be 4 years old,
Yes.
approximately.
Yes.
And so he picked him up. Is that?
Yeah, I just grabbed a hold of him.
Okay. And then where did he go?
He was pretty much walking out in the parking lot. He was pretty much walking out, just getting to the sidewalk just leaving McDonald's with my son at hand.
And did he have you said it was his visitation, but was he allowed to take your son and leave?
No, not like that.
Okay.
It was supposed to be it was supposed to be a public place, like within the premises.
So the visitations needed to be either in a public place.
Yes.
Is that correct? The visitations between your son and the defendant, or with a family member?
Yes.
Maybe with family supervision, maybe.
That too.
Okay.
And regarding to that with the family member, it didn't turn out so well with that either. Which one did you want?
So let's say at the McDonald's though.
Yeah.
And was there a time that your dad arrived?
Yes, I called my dad because he wasn't too far from the area. So that's why he immediately arrived to the scene. And I explained to him that I couldn't get my son. I was asking Otis to please give me my son back. But he wouldn't. He just wouldn't listen.
And what was the defendant doing with your son?
He was holding my son. He was just walking away, just pretty much walking away, taking him with him.
Okay. And so what did your dad do to intervene?
Once my dad showed up, he said the same thing, pretty much the same thing about my son. Like, please give my grandson back. Otherwise,
He'll have to take him?
yeah.
And so did the defendant give, your son, your dad's grandson, back to y'all? Without your dad intervening?
No. It didn't work out that way. Because he didn't listen, he was holding my son, and then once my dad started to approach him, that's when Otis got nervous and he started about to take off. But my dad got a hold of him, and at that time, I was able to get down.
And did the defendant say anything to your dad once you were able to get your son?
Yes.
What was he saying?
He was saying help, police, and all that. He was just crying for help in a way that he felt like he was targeted.
Did he say anything specifically? I mean, you felt like he was targeted, by you and your dad?
Yeah, because of my son.
And so but I guess my question was he saying, do you recall or whether or not he was saying things, profanities or other things towards your dad?
Yes, he was saying profanities to him too.
And what do you recall specifically that he said?
Pretty much saying that he called me the N-word nigga.
To your dad?
Yeah.
Were there other times, you were going to say another incident, and I said, well, let's finish the McDonald's one?
Oh. Are we finished with the McDonald's one? Because I couldn't.
Did we finish the McDonald's?
Yeah.
Okay. But was there another incident that you were going to describe?
Yes, regarding to the family member, it was his mom. Because with that, we had to have a mediator come between to pretty much help us out with regard to the visitation, because he wasn't allowed to see my son at a certain point. I believe it was due to protective order.
Okay. And so then what happened?
And well, with that, me and his mom both agreed to meet up at a certain place. Like for one, I remember to meet up at a school where I drop off my child, and his mom pick my son up.
Okay.
Once that happened, I couldn't help but get the feeling that Otis was at the house, at his mom's house there.
But did she tell you he was at the house?
She never did. It was just that I know like few times when I went to drop him off, I just felt like I had a hunch or heard a voice that sounded similar to his. And then I know at one point when I asked her, do you mind if I come in? Do you mind if I go use the restroom? She would make an excuse like,
Judge, I want to check this hearsay testimony with someone else.
Let's get the next question.
Okay. So there were times then that your son would visit his grandmother, Sandra. When you say his mom, you're referring to Sandra McKane. Is
yes.
that correct? Okay. But part of the either the visitation order was that Otis could not be there.
Right.
Okay. And so were you concerned that he was there?
Yes.
Violating the visitation order.
Yes.
Okay. And so, or did you find out on these occasions or some occasions that he was there, but you were not notified of that?
Oh, I was aware that he was there. Like I had I just felt it and I could tell, and at one point when I decided to go with my hunch and go to the police station and talk to them about the situation, I went ahead and went back and I asked Sandra to pretty much pick up my son. And once I did, she didn't like that at all. But lo and behold, discovered that Otis was there. That he wasn't be there.
He wasn't supposed to be there. Right?
Yeah.
Okay. Now going back to child support, he was ordered to pay approximately how much money per month?
About 131 or so, around that.
Okay. And did he regularly pay the child support?
Absolutely not. Not regularly.
And $131 a month is what he was ordered to pay for your son?
Right. It was due to that point when at that job. Yes.
Okay. And so the various amounts that you did receive were based on, how did you receive the various amounts of child support?
I know it was mostly through a card. So can pretty much just call in and see the exact amount and when it was pretty much added.
So just so we understand, so money, if an individual works, then money is taken or garnished from the paycheck?
Right.
And then sent to you on a card?
Yeah, yes.
Like
a little simple plastic card.
Okay, like a debit or some sort of card like that you're able to use to buy things for your son?
Yes.
And is it fair to say, at this $131 or so per month, that at the time that he would go long periods of time without making any payments whatsoever?
Yeah, because in the beginning it was frequently, but then suddenly, as time passed, it was less frequently, and it was like a big gap at a certain amount, like almost a year or so. It wasn't as big as sporadic.
And when was the last time that you and your son saw the defendant prior to November 20th of 2016?
Can you say that again? I'm sorry.
So November 20th of 2016 is the day that the defendant shot and killed Detective Benjamin Marconi, that Sunday. Prior to that day, November 20th, 2016, when's the last time you or your son saw the defendant or had any contact with him prior to that date?
It's been it's been, as of 2016, 7 years, we haven't really had much contact. He would just reach me through my old cell phone number. I've
Judge,
never.
the answer requires a date, not a statement like this.
Next question.
So I understand. We know the date, and in fact, the police talked to you, right? That you
Yes.
came in and talked to them after the defendant was arrested on November 21st of 2016?
Yes.
Okay. So prior to that time, how long had it been between that date, November 21st or 20th of 2016, and a date earlier that you had spoken to or seen the defendant, or your son had spoken to or seen the defendant?
Not since that incident that happened in McDonald's, and that was in 2014.
Okay, so
Since
2
around.
years had gone by,
Yes.
and you hadn't spoken to the defendant, nor had your son, you nor your son had seen or spoken to the defendant.
We haven't met in person. He would just frequently text here and there, but I wouldn't hardly communicate with him.
Okay. And why was that?
It's just to protect myself and my son.
And was there another incident prior to, obviously the McDonald's incident in 2014, but prior to that date where the defendant had also choked you on another occasion?
There's been several. There's been a few incidents, yes.
And when was you said this went to you, can you give us some information or details about another time that he choked you? I mean, it seems like what you're saying, have there been multiple dates and times where he has threatened you? Threatened
Yes.
to kill you?
I just can't recall on the dates per se, specifically.
But you can recall the events?
I recall a few events, like, that he would, for his hostile behavior, yes.
And the other time, was there a time in his room that, meaning his bedroom, that he had tried to choke you or was choking you?
Yes.
Can you tell the jury about that time?
At that time, yes, he was very forceful. He did grab a hold of me. Just seemed like I couldn't breathe. I was nearly to the point of blacking out. I was doing my best to reason with him about not trying to. Just try my best to reason him to try not to choke me to the point where I was blacking out to the point where I could have died.
Were you scared?
Yes, I was scared.
And so what happened? How did you get him to stop choking you?
Like I said, I did my best to try to breathe with him. I just was trying to find a way to make him stop. But eventually he did. He did.
And so how would you, if you could tell the jury kind of from, and during the time you and the defendant, from the time when you met him in 2009 until, I guess at any point, did you and the defendant ever live together?
We have never lived together whatsoever.
Okay. And so would you, kind of ending this line of questioning, how would you describe your relationship with the defendant in terms of how he treated you?
Judge, I think that has been repeated several times and is repetitive and plain open-ended as well.
All right, I'll just allow this question.
Our relationship, it wasn't really the best at all, but I learned some personal lessons about it. It's just that you shouldn't know to that verbal, physical abuse because it would take a toll on you.
I'll pass the witness.
Are we approach one?
Yes. All right, members of the jury, we're going to go ahead and let you go for the day. Tomorrow, come back at 1:30. 1:30, we should go through till about this time. All right, we'll see you tomorrow.
All right, to agree.